Here, yes. Okay, we've got the recorder going. Member Bitzer, are you present?
I am indeed.
Good morning. Member Carrasco?
Present.
I see you. There you go.
Present.
Okay. Thank you. Member Curry, I want to call him for the record. He is out for a period of time this morning. Chair Ely.
Present.
Member Garcia. Again, just for the record, she is absent. And Vice Chair Sweeney.
Present.
You have a quorum.
Thank you. So next item on the agenda is to approve the February 23rd agenda, today's agenda. Do we have a motion to approve the agenda?
So moved.
Is there a
Second.
second? Any discussion? There's no discussion. Pam, will you do a roll call on approval of the agenda?
Yes, that was Vice Chair. You made the motion and Member Carrasco, you seconded?
Correct.
Okay, got it. Member Bitzer, how do you vote?
I vote yes.
And Member Carrasco?
Yes.
Thank you. Chair Ely
Yes.
and Vice Chair Sweeney.
Yes.
Motion passes.
The third item on the agenda is approval of the February 12th, 2026 meeting minutes. These went out by email by Ms. Jones recently. Is there a motion to approve those meeting minutes?
I'll
move-
move to, go ahead.
Go ahead, Member Bitzer.
I'll move to approve the February 12th, 2026 minutes.
I second.
Is there any discussion about the meeting minutes? If there is no discussion, Pam, will you do a roll call on approval of the meeting minutes from February 12th?
Yes, ma'am. Member Bitzer, how do you vote?
I vote yes.
And Member Carrasco?
Yes.
Chair Ely
Yes.
and Vice Chair Sweeney.
Yes.
Motion passes.
Thank you, Pam. The next item on the agenda is to move to EIB 25-61, public hearing in the matter proposed adoption of 20.13.2 NMAC per and polyfluoroalkyl substances in consumer products. Felicia Orth is hearing officer. Felicia, please take it away.
Thank you very much, Madam Chair. Good morning. My name is Felicia Orth, hearing officer appointed by the board to conduct a hearing in EIB 25-61. This is the proposed adoption of 20.13.2 of the New Mexico Administrative Code per and polyfluoroalkyl substances in consumer products. The petition was brought by the New Mexico Environment Department, Office of Strategic Initiatives. We have a number of parties in this action. I'd like to call for appearances first. On behalf of the petitioner, Mr. Smith-Keir, would you like to begin?
Certainly. Greg Smith here on behalf of NMED with my co-counsel Mark Roseborough and Andrew Knight, here with Christina Keys, who's the acting director of Department of Strategic Initiatives.
Thank you very much. Let's see, Mr. Molenberg. We need you at a microphone, unfortunately.
Good morning, Madam Hearing Officer. I'm in the back bench today, but Dal Mullenberg from Gallagher and Kennedy on behalf of the American Chemistry Council and also on behalf of CropLife, and I will let my colleagues introduce themselves for appearances.
Thank you very much. Mr. Trujillo.
Madam Hearing Officer, members of the board, TJ Trujillo for the same clients that Mr. Mullenberg introduced.
Thank you.
Good morning, Serafina Saluja, also the same. Thank you.
Thank you very much. Mr. Boutsier, let's see, there you are.
Good morning, Madam Hearing Officer, board members. Stuart Boutsier of the Modrell Sperling firm, representing the PFAS Pharmaceutical Working Group. And I will be here today and tomorrow, and my partner Stan Harris will take it from there.
Thank
Thank
you
you.
very much. And Mr. Rivera, let's see. Or Ms. Feibig or Ms. Maripesi.
Yeah. Good morning, Madam Hearing Officer and members of the board. Rebecca Feebig from the law firm of Wiley Ryan on behalf of the Complex Products Manufacturers Coalition and the Alliance for Automotive Innovation. And I'm joined by my colleague, Martha Maripes, who I'll allow to introduce herself.
Thank you very much.
Good morning, Madam Hearing Officer Martha Maripes with the Complex Products Manufacturers Coalition and representing also the Automotive Innovation Alliance.
Thank you. Let's see, do we have Mr. Weatherby? Probably on the platform.
Good morning, Madam Hearing Officer and members of the board. I'm here pro se, and thank you very much for conducting this hearing.
Thank you. And Stephen Bennett, Dr. Bennett? He may have stepped away. All right. Let's see, I wanted to mention that the hearing is being recorded and transcribed by David Lee of Cumbre Reporters, and I will probably be issuing the same reminder all week, which is to speak slowly, especially if you are reading from something, and to spell names or words that aren't in the common parlance, and again, just to speak slowly. Also, the hearing is being interpreted simultaneously between English and Spanish. Ms. O'Grady, would you please make an announcement as to how to access the interpretive channel?
Yes, good morning, Madam Hearing Officer. This morning we have two New Mexico Court Certified Interpreters present, Melinda Mas and Amelia Cardena. They are interpreting from English into Spanish. And if for anyone online that would like to access the interpreter channels, at the bottom of your screen, you should see a globe. All you have to do is click the globe and then choose Spanish. And then also you can slide the bar to hear more of the interpreter or more of the main floor. If there's anybody present today that would like to, here in the hearing room, that would like to listen to the interpretation, please meet me at the back of the room and I will provide you with headsets. Buenos días a todos. Si hay alguien en la plataforma Webex que quisiera escuchar a la interpretación al español, por favor, miren en la esquina inferior a la izquierda y ahí puede hacer clic sobre el globo y luego escoge español. Si quiere escuchar más a las intérpretes, entonces pueden deslizar la barrita hacia la interpretación, sino hacia el audio principal. Si hay alguien aquí presente que quisiera escuchar la interpretación al español, por favor, vengan a verme ahí atrás y le entrego el equipo.
Thank you very much, Ms. O'Grady. Let's see. I wanted to assure people there will be a morning break in about an hour and a half. There will be a lunch hour. There are a number of fine restaurants in the area. And then there will be an afternoon break. We will, because we'll already be taking a lunch break, we will break into the technical testimony to accept public comment, to invite public comment specifically at 1 p.m. each day. We had 4 motions filed before the hearing, and in the pre-hearing order that was issued some weeks ago, I agreed to hear replies before we leapt into the evidentiary record. Is there any other preliminary matter before we do motions, and then I'll invite opening statements? Any other preliminary matters? No.
Madam
Yes.
Chair, no, I did have a question about where witnesses are going to be located and the questioning attorney. Are you planning on having witnesses in the box?
I think that's an excellent place for them. We do have cameras trained on that witness box right there. And to the extent folks would like to present a panel, we can certainly make use of this table that would otherwise be a council table.
Okay. And second practical question, with respect to demonstrative exhibits, will the witnesses take a laptop up and work those themselves, or how's that going to work?
So we can have the demonstrative exhibits shared on the screen so that everyone is looking at the same slide at the same time. Pam or Luis, would you like to address that question further?
Yes, Counselor, it'd be best if you signed on to the WebEx platform and then shared your screen from that, or the witness could do the same.
Thank you.
You're welcome.
Thank you, Mr. Smith-Care. Okay, anything else before we turn to the motions? All right, let's see. Let me take this one first. American Chemistry Council's motion in limine to exclude the Environment Department's technical information undisclosed in public notices. I have reviewed the motion and the response from the Environment Department. Who would like to offer the reply?
Madam Hearing Officer, I will.
All right, please go ahead, Mr. Trujillo.
Give me 1 second. Let me find my stopwatch. We got 10 minutes, right?
Yeah.
Good morning, Madam Mayor and Officer, and members of the board. Can you hear me all right?
Yes, sir.
My name is TJ Trujillo, and I am appearing on behalf of the American Chemistry Council, otherwise known as ACC. This motion in limine presents a narrow but fundamental question. May an agency withhold the bulk of technical information that forms the basis for a proposed rule until after the public notice is issued, and then rely on that undisclosed material at hearing? The State Rules Act answers that question clearly. It says no. ACC is not asking the board to restrict legitimate testimony, inhibit stakeholder engagement, or freeze the rulemaking record at any time. Instead, ACC is asking that the board enforce the legislature's notice and participation requirements by excluding technical material that should have been disclosed but wasn't when the public was formally placed on the clock. Section 14-4-5.2A7 of the State Rules Act requires that at the time of public notice, an agency must provide, quote, a citation to the technical information, if any, that served as the basis for the proposed rule. That language is mandatory, and the same language is also found in the board's rulemaking rules at 20.1.301B2 NMAC. The statute is not aspirational, and it is not limited to some technical information. The statute says initial technical information. The statute does not say initial technical information, and it does not say illustrative technical information. It says the technical information that served as the basis for the proposed rule. The policy reason is obvious and important. Public notice is not a procedural formality. It is the moment when regulated parties, experts, or members of the public must decide whether and how to engage. They must assess what the agency is proposing, why it is proposing it, and what technical assumptions underlie the proposal. Without access to that information, meaningful participation is impossible. In this case, NMED's public notice identified 19 publications as the technical basis for the rule. However, when the notice of intent was filed just over a month later, NMED disclosed 68 technical exhibits, many containing dozens or hundreds of additional citations. By ways of example, I point you to the testimonies of Dr. Chapman and Dr. DeWitt. If I counted things properly, Dr. Chapman's testimony cites 113 publications, only 3 of which appear in the public notice. Meanwhile, Dr. DeWitt's testimony cites 88 publications, again, with only 3 disclosed. This is not supplementation at the margin. This is not clarification. This is wholesale expansion of the technical base after notice had already issued. At that point, the parties were already preparing their cases, retaining experts and developing testimony based on what the agency told the public was its technical information. That is precisely the harm the statute is designed to prevent. NMED argues that section 14-4-5.2 establishes only a floor for disclosure, but that argument fails for three reasons. First, it contradicts the plain language of the statute. The statute does not require disclosure of some technical information. It requires disclosure of technical information that served as the basis of the proposed rule. Second, NMED's interpretation would nullify the notice requirement entirely. Third, this reading creates exactly the kind of absurd result the Uniform Statute and Rules Construction Act forbids, a system where the agency controls when and whether the public ever sees the real technical justification for the rule. The legislature did not design public notice as a sneak peek to the rest of the story. It is supposed to be the full and fair disclosure of the rule's technical foundation. NMED also argues that ACC's interpretation of section 14-4-5.2A7 renders section 14.4-5.4 superfluous. It does not. The two provisions serve different functions at different stages. Section 14-4-5.2A7 governs what must be disclosed before hearing, so the public can prepare. Section 14-4-5.4 governs what must be included in the final rulemaking record, reflecting what was ultimately relied upon. Those provisions work together. They are not substitutes for one another. The prejudice here is not hypothetical. Once public notice issues, parties are immediately constrained by deadlines, expert retention, testimony preparation, and evidentiary strategy. When the technical basis expands dramatically after notice to regulated entities, it presents a significant problem. This is especially problematic in rulemakings of this scope, where technical literature defines the reach of the regulation, including which PFAS compounds are implicated and why. If certain classes of compounds were not supported by disclosed technical information at notice, regulated parties were entitled to assume those compounds were not within the rule's intended scope. Late disclosure changes the game midstream. That is not meaningful participation. That is a procedural ambush. What ACC is and is not asking for, let me be clear about the remedy ACC seeks. ACC is not arguing that NMED must have fully drafted testimony on notice, that no technical evidence may ever be introduced after notice, or legitimate rebuttal testimony should be excluded. Instead, ACC is asking for a much narrower and legally compelled result, that NMED not be permitted to rely on technical information that served as the basis for its proposed rule, but was never disclosed to the public when the notices were issued. The appropriate remedy for a notice violation is exclusion, not because the evidence lacks scientific merit, but because procedural fairness matters. In conclusion, the State Rules Act strikes a deliberate balance between agency expertise and public participation. That balance only works if agencies disclose the technical foundation of the proposals before the public is required to respond. Here, NMED did not do that. For those reasons, ACC respectfully requests that the board grant the motion in Lamine and exclude NMED's exhibits that rely on undisclosed technical information. One final issue, Madam Hearing Officer, members of the board. If you are inclined to grant the motion in Lamine, ACC would respectfully request that you give us some additional time to discuss a process for identifying which exhibits must be excluded. Alternatively, if you are inclined to deny the motion, ACC would respectfully request that you defer ruling on the motion in Lamine until ACC can cross-examine Dr. Eric Chapman, as he appears to be the appropriate witness with the knowledge and understanding of how and why public notice was compiled, which includes the technical information disclosed in public notice. After such testimony, ACC can renew its objections to any undisclosed technical information. Thank you.
All right, thank you very much, Mr. Trujillo. I certainly understand the interest in having complex technical information sooner rather than later as every party prepares for complex rulemaking. Having said that, my experience and reading of Chapter 14 and of course the board's rulemaking rules is that these rules and rulemaking are informed by technical information that comes in and is developed throughout the process and not, if you will, just by what is captured in the initial public notice. So I'm denying the motion in limine to exclude the department's technical information. I will certainly, you'll have an opportunity to cross-examine Dr. Chapman, an opportunity to develop the questions you have about the public notice. And we'll certainly offer you every opportunity to preserve your objections. Thank you. Let's move then to the New Mexico Environment Department's motion to exclude portions of the Complex Products Manufacturers Coalition's notice of intent to present technical testimony and Exhibit 3. This is the written technical testimony of Martha Maripes. Mr. Smithcare.
Thank you, Madam Hearing Officer. In their response to NMED's motion in limine to exclude the testimony of Martha Maripes, CPMC raises several arguments that I'm going to address in turn. CPMC argues that NMED's motion in limine relies on rules of evidence which are not applicable in this rulemaking proceeding. They also argue that Ms. Maripes is qualified to opine in the areas of economic, health, and environmental impacts of PFAS. While the rules of evidence do not strictly apply under the EIB procedural rules, the requirement to provide technical testimony in the procedural rules indicates that a person must be qualified in order to provide technical testimony. In particular, 20.1.1.302A2 NMAC states that a notice of intent to provide technical testimony shall include the qualifications of that witness, including a description of their educational and work background. This is similar to the requirements of the New Mexico Rules of Evidence 11-702, which considers an expert's knowledge, skill, experience, training, or education with respect to qualifications. Further, if a witness did not need to be qualified to offer technical testimony based upon their educational or professional backgrounds, then 20.1.302A2 requiring the witness's qualifications and educational and work background would be superfluous. Laws in New Mexico must be interpreted to avoid rendering them superfluous. Because of that, Ms. Maripes must be qualified to provide technical testimony. CPMC's response discusses Ms. Maripes' qualifications, but nothing that CPMC included indicates that Ms. Maripes has any training as an epidemiologist, toxicologist, or other health professional that would qualify her to speak on the human health impacts of PFAS. Further, she has no training or professional experience in any medical field. The same is true with respect to
Slow down. Yes, slow down just a little bit,
Too fast?
Mr. Smith.
Okay, sorry about that. The same is true with respect to environmental science. CPMC did not indicate that Ms. Maripes has any training in environmental science, and her work as an environmental law attorney does not qualify her to opine as to the complex ways in which PFAS impacts the environment. Despite CPMC's assertions, submitting comment letters on PFAS-related regulations, such as TSCA, does not make one an expert on human health or environmental science. Further, Ms. Maripes is not a trained economist. She does not have an advanced economics degree, and CPMC has not indicated that she has ever worked as an economist. Finally, CPMC does not directly address NMED's arguments related to the legal arguments that Ms. Maripes raises related to legislative intent. These are not technical testimony under the rules. and should not be permitted to offer them as if they are technical testimony. CPMC also argues that to the extent that any part of Ms. Marapisa's technical testimony is deemed non-technical, the proper action would be to treat it as non-technical testimony and weigh its value accordingly. Allowing Ms. Marapisa to testify on topics that she is not qualified to offer technical testimony on should not be allowed. Assuming Ms. Marapisa is allowed to testify with respect to some topics and not others, it would be confusing to allow her to offer all her testimony and leave it to the board to tease apart which areas she's qualified to testify to and which she is not. Her written testimony weaves these topics together, and her oral testimony will presumably be similarly intertwined. For these reasons, NMED respectfully requests that you grant its motion in limine to exclude the testimony of Martha Marapisa at this hearing and strike her written direct testimony from the record.
Thank you, Mr. Smith-Care. Going to deny this motion as well. I certainly saw, as you described, the weaving of both technical and non-technical testimony, the weaving of testimony that perhaps she would be clearly qualified to give, and testimony perhaps adjacent to areas of expertise based on education and experience. Rather than tease that out, though, or exclude her entirely, I'm going to, and I know you already know this, stress that you'll have an opportunity to cross-examine Ms. Marapisa, and to the extent she's offering testimony that should not be fully relied upon or relied upon without caveat, I think that really goes more to weight than excluding her altogether. Let's turn then to the department's motion to exclude Dr. Bennett's testimony. I saw your motion. I did not see a written response from Dr. Bennett. Am I wrong about that, Pam? All right. So let me ask if Dr. Bennett is on the platform or in the room. Called on him earlier. Do you see him on the platform, Luis?
Madam Hearing Officer, I do not see him on the platform.
All right. Well, certainly based on the motion, I am inclined to grant it. We have these rules for a reason, obviously, in a complex rulemaking. His entry of appearance was timely filed, but his technical testimony was weeks out of time, as I saw it. And certainly if he joins us on the platform and seeks to make a response, I will accept it, Luis. But in the meantime, you certainly know what my inclination is, Mr. Smith-Care. All right, let's turn to the final motion, the fourth motion. This was titled Memorandum and Brief, I believe. Let's see here. Yeah, a motion and memorandum brief in support by the Complex Products Manufacturers Coalition and Alliance for Automotive Innovation. I read the motion and the brief, and of course the response by the department. Who will be offering the reply?
I will, Madam Hearing Officer.
Thank you, Ms. Feebig.
Good morning, and thank you, Madam Hearing Officer and members of the board, for the opportunity to reply to the motion that has been set forth. Without conceding any points from our initial submission, and in the interest of time, I want to focus on just 3 issues that I'd like to discuss in reply to the Environment Department's opposition. First, the labeling requirements continuing First Amendment problem. Second, the board's statutory authority to impose a labeling requirement on complex goods. And third, the need for clarity about federal preemption and manufacturers' obligations under HB 212 and the proposed regulations. The precise contours of NMED's proposed labeling requirements have been evolving since the proceedings began. And to be clear, the CPMC and auto innovators appreciate NMED's willingness to reconsider and make revisions to the proposed regulations.
Slow down a little bit.
Yeah, that said, even in the newest iteration, the proposed labeling requirement still violates the First Amendment and New Mexico's analogous provision in Article 2, Section 17 of the state constitution. As they currently stand, the proposed regulations require manufacturers to label their products with the outline of an Erlenmeyer flask and the word PFAS inside the flask. NMED contends that this is simply factual and non-controversial, but the clear intent of the label is to imply that PFAS as a class are harmful and should be avoided. As explained in our moving papers, that is not a scientifically accurate position. The issue is exacerbated by the fact that NMED is also telling New Mexicans via its website, although it has been revised, that PFAS are forever chemicals that cause a laundry list of maladies to both people and the environment. In other words, NMED seeks to make the label PFAS into a scarlet letter. In this way, the current proposed regulations are similar to a disclosure requirement that the DC Circuit struck down in 2014 on First Amendment grounds that would have required companies to disclose which of their products were not, quote, conflict-free, meaning products containing minerals that either directly or indirectly financed militant groups in Central African countries. And that's the National Association of Manufacturers versus SEC, and that's a DC Circuit case from 2014. The DC Circuit held that this mandatory disclosure violated the First Amendment because the conflict-free label in context was not factual and non-ideological, but instead conveyed a moral message about the company's purported responsibility for armed conflict in those African countries, essentially requiring the company to tell consumers that its products were ethically tainted. According to the DC Circuit, by compelling a company to confess blood on its hands like this, the disclosure requirement interfered with the exercise of freedom of speech under the First Amendment. Further, in addition to being factual, the label must also be uncontroversial. NMED claims that standard is met because there is consensus in the scientific community as to what constitutes PFAS. However, we submit that would be the wrong question. The question is whether there is consensus regarding whether PFAS as a class cause harm. And there is not, which NMED has essentially conceded via the changes it has already made to its labels. Given the context in which the labeling requirement is being proposed, with the Environment Department telling New Mexicans that PFAS are harmful as a class, the labeling requirement, even as revised, still compels manufacturers to convey a scientifically unsubstantiated moral message. As such, it runs afoul of the First Amendment. Second, the proposed labeling requirements for complex durable goods are inconsistent with the statute. NMED argues that HB 212 is clear and unambiguous, and its plain language should govern the question of whether the board should impose a labeling requirement on exempt products. We agree, and the plain language of the statute confirms that the regulations as proposed should not be implemented. NMED's focus on two provisions alone in the statute is too limiting. HB 212 Section 4B permits, but does not require, the board to adopt rules to carry out the provisions of the statute and specifies that labeling may be an element of that task. The provisions of HB 212, which the board is charged to carry out, include an exemption from the statute's reporting requirement for most complex durable goods. Section 4A1 of the statute, which is deals with the grant of authority to the board to promulgate regulations, says the board shall adopt rules to exempt from the reporting requirements any product that is exempt from the bans. Complex durable goods exempt from the bans include motor vehicles, vessels, HVAC equipment, semiconductors, non-consumer electronics, and certain electrical equipment. The statute's exemptions for products presenting preemption issues and products containing fluoropolymers likewise apply to many complex durable goods. However, the proposed rules labeling requirement for complex durable goods which require a manufacturer to include in its operation and technical manuals a comprehensive list of all components containing PFAS and information sufficient to identify their location, is akin to the reporting requirement. And manufacturers seeking an exemption from labeling, including manufacturers who've been given a currently unavailable use exemption, must provide all the information required by the reporting provisions and more. These labeling provisions are inconsistent with the statute and should not be adopted. Finally, on preemption, let me say that we do appreciate UnMed's recognition that where federal law regulates PFAS containing textile articles and refrigerants for motor vehicles, neither HB 212 nor its implementing regulations will apply to those products. The concern we still have on this point is that under the current proposed regulations, manufacturers of such products will have to make a judgment call as to whether HB 212 and its implementing regulations are federally preempted as applied to those products. And if the board disagrees with that judgment call, manufacturers could face significant liability. The board could provide regulatory clarity by adopting CPMC and Auto Innovator's proposal of striking the language in proposed 2013-2010G that suggests such products are not exempt from HB 212 and its implementing regulations. Or if the board is disinclined to do that, at the very least, it could consider adopting something to provide regulatory certainty in this area, perhaps a safe harbor immunizing manufacturers from liability for noncompliance with the requirements if that noncompliance arose out of a good faith belief that they were trying to comply with preemption or avoid preemption. Thank you.
Thank you, Ms. Fabig. So for now, I'm denying the motion, but I'm denying it with the understanding that what it teed up for the board and its council are a number of mixed questions of fact and law, and that the board will, in its deliberations, have to answer these questions on their way to making a decision on the rule. So for now, it's denied, but I don't want to suggest to you that these questions have been resolved. So we're going to proceed with the hearing, and I believe the fullness of the record will help the board make its decisions on these questions. So thank you for that. All right, is there anything else before we move to opening statements? No? All right. Mr. Smithcare, would you like to offer the first opening statement as petitioner? And if you'll remember, you have 20 minutes.
Thank you. Good morning, Madam Hearing Officer, Chair Ely, and members of the board. My name is Greg Smithcare, and I'm here today on behalf of the New Mexico Environment Department's Office of Strategic Initiatives.
Slow down.
I'm joined here today by Christina Keys, Acting Director of Office of Strategic Initiatives, as well as my co-counsel Mark Roseborough and Andrew Knight. My co-counsel and I are here to assist an incredible group of department staff and experts to put forward explanations and support for this board to adopt 20.13.2 INMAC, a rule relating to per and polyfluoroalkyl substances in consumer products. This rule implements the landmark PFAS Protection Act that was signed into law by Governor Lujan Grisham on April 8th, 2025. The PFAS Protection Act was a clear directive from the New Mexico legislature to protect our citizens, our water, and our environment from the forever chemicals known as PFAS. The ambitious timetable that has been set forth by the legislature in the implementation of the PFAS Protection Act underscores the urgency of addressing PFAS in consumer products, and this hearing is an important step towards turning off the spigot of PFAS in New Mexico. The first product prohibitions contained in the PFAS Protection Act go into effect on January 1, 2027. Because of that, time is of the essence with respect to adopting a rule to implement the Act's requirements. The rule that NMED has proposed incorporates all the statutory mandated requirements and it aligns with the legislature's goals as expressed in the PFAS Protection Act and the recently passed House Joint Memorial 3. Specifically, the proposed rule fulfills the requirements of the legislature that the board, 1, adopt rules that detail the information that a manufacturer must report to NMED, 2, adopt rules to exempt products from the statutory reporting requirements if those products are already exempt under the Act, 3, adopt rules creating a series of ranges of the amount of PFAS in a product for reporting purposes unless they are exempt, and 4, adopt rules to identify the currently unavoidable uses of PFAS that are essential for health, safety, or the function of society, and for which there are no reasonably available alternatives. In addition to these requirements, NMED's proposed rule requires labeling of products containing intentionally added PFAS in both English and Spanish, as authorized by the legislature. The rule also requires the labeling of exempt products, which aligns with the will of the legislature as expressly stated in House Joint Memorial 3, which was passed just last week. The introduction of a PFAS label for consumer products will allow New Mexicans to make informed decisions with respect to the products that they purchase and bring into their homes by making transparent which consumer products contain intentionally added PFAS. In addition, NMED's proposed rule contains enforcement and penalty provisions for violations of the Act and the rules adopted pursuant to that Act in accordance with the legislature's mandate. All of these elements of the rule work together to empower the department to effectively manage one of the significant sources of PFAS contamination and to protect the health of New Mexicans. Throughout the development of the drafts of the proposed rule, which has led to the rebuttal rule that NMED is asking the board to adopt, the department engaged with interested parties and incorporated their feedback through rule revisions. NMED began engaging with interested parties for rule development in August of 2025. The department has met with all interested parties who requested a meeting. All told, the department has met with more than 56 interested parties and 99 representatives from those interested parties since August 2025. The result of this collaboration with stakeholders is a proposed rule that strikes the balance of protecting the health and welfare of New Mexicans without unduly burdening industry. Over the next week, the technical testimony presented by the New Mexico Environment Department will demonstrate that the proposed rule is far more than a regulatory formality. It is a critical safeguard for both environmental integrity and public health. This testimony will provide a comprehensive look at the specific vulnerabilities and risks New Mexico faces regarding PFAS. NMED's experts will explain why New Mexico's groundwater is exceptionally susceptible to PFAS contamination. This is a matter of urgent public concern, as 80% of New Mexicans depend on groundwater for their primary drinking water supply. Witnesses will explain preventing these chemicals from entering the ground in the first place is the only viable path forward. It is a proactive strategy that is significantly more cost-effective than trying to extract and treat PFAS once it has already permeated the state's aquifers. The board will hear testimony regarding Holloman Lake, where researchers have documented some of the highest global concentrations of PFAS ever recorded in plant and animal life. Expert testimony will illustrate the severity of contamination in the local ecosystem, showing how these chemicals move through the food chain and persist in the environment at levels that challenge global benchmarks. The department will present a sobering analysis of the staggering costs associated with PFAS remediation. Witnesses will testify that once PFAS is released into the environment, managing it becomes both economically and technically infeasible. Even under the most aggressive and well-funded cleanup scenarios, remediation efforts would likely only capture a small fraction of current emissions, leaving the vast majority of the contamination to persist indefinitely. NMED's human health experts will testify to the widespread nature of human exposure and the specific medical risks associated with PFAS. The testimony will link some PFAS to a range of severe health outcomes, including the increased risks of kidney and testicular cancers, adverse effects such as low birth weight in newborns, and significant immune system toxicity. Finally, the testimony will address the practical efficacy of the proposed labeling requirements. Experts will provide evidence on how clear, conspicuous labeling influences consumer behavior, provides tangible benefits to consumers, and gives New Mexicans the transparency that they deserve. By informing the public about which products contain intentionally added PFAS, the state can empower residents to protect their own health and the environment. Through this week of expert testimony, NMED will prove that this rule is a necessary and overdue intervention to protect the future of New Mexico's land, water, and its people. The rule before you today is a practical, balanced, and legally sound framework. It fulfills the mandate of the PFAS Protection Act and honors the urgency expressed by the legislature. By adopting this rule, the board will provide the department with the necessary tools to track these chemicals, inform our citizens through transparent labeling, and ultimately prevent further contamination of the groundwater that 80% of New Mexicans rely on for drinking. We are not just asking you to adopt a regulation. We are asking you to turn off the spigot of PFAS in New Mexico. We have the science to prove the risk, the legislative authority to take action, and a clear path forward that protects both human health and the environment without placing an undue burden on manufacturers. On behalf of the New Mexico Environment Department, we urge the board to adopt the proposed rule in its entirety. Thank you for your time and for your service to the state of New Mexico.
Thank you, Mr. Smith-Kerr. I realized we did not, in our second pre-hearing conference, arrange the industry parties. Have you decided on an order yourself that you would like to proceed? Mr. Mullenberg.
Thank you, Madam Hearing Officer. I believe that with other councils' concurrence, American Chemistry Council could go first. We can follow that, of course, with CropLife, and then probably proceed to the Complex Products Manufacturers Group.
Thank you very much. All right, let's do that. So, will you be offering an opening statement at this time, or would you like to reserve?
Madam Hearing Officer, we will reserve until before we produce our first witness.
Thank you very much. So for CropLife?
Madam Chair, we will also reserve until we present our direct.
Thank you. And for the Complex Products Manufacturing Coalition?
Good morning, Madam Hearing Officer. Madam Chair, Madam Vice Chair, may it please the board, Rebecca Fiebig again, on behalf of the Complex Products Manufacturers Coalition, which I'll refer to as CPMC for the rest of the hearing and might make it easier if you all do as well as the Alliance for Automotive Innovation, which I'll refer to as Auto Innovators. CPMC is an industry group comprised of manufacturers of a broad range.
I'm sorry, ma'am, can you slow down a little bit, please? CPMC is an industry group.
Yeah. Comprised of manufacturers of a broad range of complex products such as HVAC, appliances, outdoor tools, vehicles, vessels, and electronics that share common characteristics and challenges. Auto Innovators is itself an industry group comprised of motor vehicle manufacturers and is also a member of CPMC. Thus, when I refer to CPMC member products, I'm including Auto Innovators in that category as well. CPMC is dedicated to sensible management of per and polyfluoroalkyl chemicals, which I'll refer to as PFAS. Sustainable, science-based regulation of PFAS is a key component of sensible PFAS management. We wish to commend the state of New Mexico for its efforts in this difficult and emerging area. Thank you for taking a thoughtful and collaborative approach up to now, and thank you in advance for your continued willingness to engage on these issues. CPMC shares New Mexico's desire to see regulations implemented that will protect New Mexicans' health, provide New Mexican consumers with factually accurate and useful information, and protect the environment from dangers associated with unnecessary PFAS use. CPMC's mission is to advocate for regulations that protect human health and the environment while also supporting the jobs and products that are essential to society's well-being. And we, like New Mexico, are working with states throughout the nation and the federal government to support this mission. This work is not easy. It requires careful consideration of the science, the needs of the jurisdiction, and the benefits and burdens of the proposed regulation, which must be carefully balanced. As proposed, aspects of 2013.2 NMAC are out of balance. The burdens that certain provisions in the proposed regulations will impose on the regulated community far exceed the benefits that they will provide to New Mexican citizens and to the environment. The same reasons that lead to the imbalance also render the rule as proposed vulnerable to legal challenge on First Amendment and preemption grounds and call into question the regulation's consistency with the authorizing statute. Fortunately, these issues can be fixed, and the board can implement sensible regulations that will withstand legal challenge and, most importantly, benefit the people of the state. At the conclusion of the hearing, CPMC and Auto Innovators will ask the board to modify 2013.2 NMAC by extending all of the exemptions in 2013-210 to the labeling provisions of the law, revising the labeling requirements for complex durable goods so that they're no more onerous than the requirements applicable to other products, and clarifying that motor vehicle textile articles and refrigerants, which are either authorized by or used to meet mandatory federal safety standards, are exempt from the rule's ban and reporting provisions on preemption grounds. Over the next few days, the board will hear technical testimony from several witnesses in support of the proposed rule. That testimony will provide the board with general information about PFAS's chemical properties, the mechanisms by which they enter and the way that they behave in the environment, the costs associated with PFAS remediation, and the way that consumers generally respond to labeling. The testimony will also show that some, but not all, PFAS have been associated with adverse health or environmental impacts, and that much remains to be learned about these substances. The proponents of the rule will not, however, present evidence regarding the proposed rule's benefits and burdens as applied to specific categories of products, including products exempted from PFAS bans, complex durable goods, and motor vehicles subject to federal motor vehicle safety standards. As not all PFAS chemicals are the same, not all PFAS-containing products are the same, a fact that the legislature recognized by excluding certain categories from its product bans. Any risk and science-based regulatory enactment must also account for that reality. CPMC will present technical testimony from 3 distinguished witnesses to help the board understand the proposed rule's impact on essential complex products, including motor vehicles, and explain the reasons underlying CPMC's position that products exempt from bans and reporting requirements should also be exempt from labeling, or, at the very least, not be subjected to labeling obligations that are even more onerous than those applicable to PFAS-containing products that directly subject consumers to exposure. CPMC's witnesses will also help the board understand the need for clarity regarding preemption due to the challenges and timelines that manufacturers of heavily regulated complex products like automobiles and marine vessels face in ensuring compliance with federal safety standards. Martha Marapese is a nationally recognized environmental lawyer with substantial expertise in notice and comment rulemaking, including interpretation and application of economic impact analyses in rulemaking proceedings. She will discuss the hurdles facing complex product manufacturers under the proposed rule, including navigation of complex multi-tiered supply chains, lengthy product development cycles, unavailability of chemical composition data, and federal regulatory obligations. She will provide a framework to quantify the costs that complex product manufacturers will bear, drawing on economic analyses prepared in connection with other rulemakings, and discuss the corresponding impacts on New Mexico's consumers. Finally, she will explain why the PFAS contained in complex products generally presents low risk of exposure or is essential and has no viable substitute. Kemba Solomon, a mechanical engineer turned regulatory affairs manager for Yamaha Marine, whose focus is on compliance with forthcoming regulations, will offer a firsthand industry perspective based on her work in the marine, motor vehicle, and other sectors. Ms. Solomon will walk the board through sample labels, specification and safety data sheets, and the composition of a marine vessel to illustrate via a real-life example what compliance with the proposed rule would look like in her industry. She will also explain, by reference to marine products, the essential but not dangerous role that PFAS play in those products and the difficulties that these heavily regulated products face trying to comply with both state and federal requirements. Dr. Alex Stanton, a physical chemistry PhD and alumna of the EPA's Office of Chemical Safety and Pollution Prevention, will draw on her experience reviewing and regulating new chemicals to explain the dangers posed to consumers by overgeneralization of chemicals with different properties and risk profiles. She will discuss the properties of PFAS chemicals in use by complex products manufacturers and explain why they present low to no risk. New Mexico is a national leader in the important task of PFAS regulation. As such, it is vitally important that the rules the board implements following this hearing be grounded in today's scientific and economic reality, tailored to benefit New Mexican citizens, the New Mexican environment, and New Mexican economy, and impervious to legal challenge. As you listen to the testimony that's presented this week, we ask you to keep these considerations in mind, and we thank you in advance for your time, consideration, and service to the state.
Thank you, Ms. Feebeck. Let's see, Mr. Boutier, I'm not sure whether you want to offer an opening statement without witnesses.
Very brief, Madam Hearing Officer, members of the board, Stuart Boutier for the PFAS Pharmaceutical Working Group. We likewise commend the agency for its engagement efforts pre-hearing. We support the labeling and preemption-related provisions of the rebuttal draft of the rule insofar as they relate to the pharmaceutical industry's products, and we otherwise waive our opening statement opportunity.
Thank you very much. Let's see, I don't believe we have Dr. Bennett. Mr. Weatherby, do you have anything to say by way of opening?
Thank you, Madam Hearing Officer. No, not at this time. Thanks very much.
Thank you. All right, we're going to move then into the witness testimony portion of the hearing. Board members, I will note that Department Counsel did send to the other council, and Pam forwarded to all of us the order in which NMED anticipates presenting its witnesses. I'll just mention the first couple of them. Dr. Eric Chapman, Dr. Mitch Olson, and Dr. Andy Yocums. If I'm mispronouncing a name, please correct me when they get up here. And as I understand it, Mr. Smith-Keir, you said we're going to hear from each of these witnesses one at a time.
That's correct, Madam Hearing Officer.
All right. So if you would please call up Dr. Chapman.
The state of New Mexico, NMED, calls Eric Chapman, PhD, to the stand.
Thank you.
Madam Hearing Officer, to be clear, we go directly from his direct testimony into his rebuttal. Is that correct?
I'm sorry, I don't know who's speaking.
That was Mr. Smith-Keir.
Again, please, Mr. Smith-Keir.
Yes. Let's see, whenever Dr. Chapman is ready. The answer to your question, Mr. Smith-Keir, is yes.
Okay.
And I'm going to demonstrate here with Dr. Chapman what we'll be doing with every witness. Dr. Chapman, if you would please spell your first and last name.
Good morning, Madam Hearing Officer. My first name is Eric, E-R-I-C. My last name is Chapman, C-H-A-P-M-A-N.
Thank you. And do you swear or affirm to tell the truth?
I do.
All right, thank you. And please, both of you gentlemen, keep it slow.
Madam Hearing Officer,
Yes,
Sorry.
Mr. Trujillo.
sorry to interrupt. I would like to, at this point, move to exclude that testimony to preserve my motion in the mind. Move to exclude those exhibits that Dr. Chapman relied upon that weren't disclosed at the time of the notice in the New Mexico Register at this juncture.
All right, thank you. That motion is overruled, or objection is overruled. So I think that's all we need to do to preserve your record on that point. And Mr. Smith-Kier, if you would, please.
With respect to posting the slides for everyone to see, I've logged in. Does someone need to grant me access to do that?
Louise?
Yeah, Counselor, you should be able to just share your screen as a co-host. Let me know if you're not able to do that.
It's not letting me do it. The share button is grayed out.
Counselor, you're signed in as your name?
Yeah, Greg Smith here.
Okay, just trying to make it presenter, so that might do it. If you could try it one more time. There we go.
Great. And while Mr. Smith-Kier is making that image larger for us, I meant to say for anyone who has not necessarily read the pre-hearing order, that although the technical testimony may be lengthy for some of these witnesses who set it out in full narrative as part of their notice of intent, the pre-hearing order allows just 30 minutes for them to summarize it. So, and I'm keeping time up here. Go ahead, Mr. Smith-Kier.
Dr. Chapman, where are you employed?
The New Mexico Environment Department.
And how long have you been employed there, and what is your current position?
Since August 2025, and I serve as the Chief Science Coordinator for the agency.
Can you briefly describe your education and professional qualifications for us?
I have a PhD and Master's in Environmental Life Science from Arizona State University. I'm formally trained in biogeochemistry, a subdiscipline of environmental science focused on understanding how materials cycle within living and non-living elements in the environment. I also hold a bachelor's in genetics and cell biology and a minor in chemistry from the University of Minnesota. I serve as the technical lead for the per and polyfluoroalkyl substances in consumer products rulemaking effort. Prior to my work for the department from 2019 to 2025, I was a biology professor at the University of St. Thomas, a large undergraduate institution in Minnesota. I taught over 1,000 students introductory and upper level biology courses on human impacts on the environment with a focus on chemicals of emerging concern, including PFAS.
And did you file both direct and rebuttal written testimony?
I did.
Okay. And do you have any corrections that you'd like to make to that written testimony?
Yes. I stated that the PFAS Protection Act requires the EIB to adopt rules for testing products for PFAS. To clarify, the statute requires testing and authorizes the EIB to adopt rules for testing.
With that noted correction, do you adopt that written testimony as your testimony here today?
I do.
Okay. Can you please provide a summary of your written testimony?
I present this testimony on behalf of the department in support of the department's petition and rebuttal rule. I will provide a high-level overview of the rule and how engagement with interested parties led to the development of the rule. I will also discuss sources of PFAS in the environment, how consumer products can contribute to environmental PFAS contamination, and environmental transformation and transport of PFAS across different media. My testimony will show that once released into the environment, PFAS contamination becomes widespread creating a multitude of indirect exposure pathways that are difficult to remediate. I will end with a call for adopting the rebuttal rule to turn off the spigot at the source of PFAS entering New Mexico through consumer products.
Why is it important to regulate PFAS and consumer products in New Mexico?
One of the many catalysts for New Mexico's actions regulating PFAS is the bioaccumulative, persistent, and toxic nature of many PFAS. Another is the extent of contamination, including places such as Holloman Lake, with some of the highest levels of PFAS ever observed in plant and animal tissues globally. Surface water concentrations were measured to be over 100,000 parts per trillion, or 25,000 times the EPA drinking water standard for PFOS, and consuming 1 gram of duck meat from the lake would exceed the recommended lifetime exposure to PFOS. Prohibiting consumer products containing PFAS can turn off the PFAS spigot at its source. Consumer products are a major direct source of PFAS exposure to humans and a major indirect source once released into the environment. Humans are directly exposed to PFAS in cleaning products, cosmetics, cookware, and fabric treatments. The production, use, and disposal of consumer products can result in PFAS emissions that contaminate the environment. Passive receivers such as wastewater treatment plants, wells and septic systems, soils from biosolid application, and landfills further spread contamination to water, soil, and air. Regulating PFAS and consumer products can lessen the burden of contamination by downstream passive receivers. The PFAS Protection Act allows New Mexico to prohibit products containing PFAS. Adopting the rebuttal rule will ultimately restrict the flow of PFAS into consumer homes, cutting off the direct exposure pathways and greatly reducing the indirect exposure pathways in the environment.
Can you please provide us with a brief overview of the rebuttal rule?
This slide shows an overview of the rebuttal rule. Consumer product prohibitions, exemptions, currently unavoidable use, reporting, labeling, testing, fees, and enforcement, compliance, and penalties are the major sections. The heart of the rule is a recitation of the prohibitions of consumer products containing PFAS that were codified in statute highlighted on this slide. Prohibitions are to occur at 3 distinct time intervals by different product categories. This slide shows specific consumer product categories that are exempt from the prohibitions in the PFAS Protection Act. Here, I highlight the process to seek a currently unavoidable use.
Hold on, Dr. Chapman. Wow. I will add a minute to your time. It's going to be very hard to concentrate on what you're saying, though, if we proceed. Thank you very much, Mr. Secretary. Go ahead, Mr. Chapman, Dr. Chapman.
Thank you. Here on this slide, I highlight the process to seek a currently unavoidable use, or CUU, of PFAS. These proposals contain basic information listed on the slide that will help determine whether a particular use of PFAS is essential. To make sure CUU designations are based on up-to-date science, CUU designations expire every 3 years and can be renewed, and these will be publicly posted on the department's website. The PFAS Protection Act requires the EIB to adopt rules outlining reporting requirements. Section 20.13.2.12 establishes requirements for manufacturers to submit to the department a report outlining information about the use of PFAS in products. Reporting requirements do not apply to exempt products or those that receive CUU designations. The EIB is authorized to adopt rules to require the labeling of products containing PFAS, and the rule contains provisions to label products with an Erlenmeyer flask symbol and non-controversial statements of facts disclosing the presence of PFAS. Section 20.13.2.13 on labeling represents the culmination of collaboration with interested parties throughout the rulemaking process. Specifically, the department removed label language about environmental and human health effects and a link to the department website. Furthermore, the department enumerated several additional labeling exemptions for products subject to federal law, addressed feedback about products being on retailer shelves by indicating that products manufactured, not sold after January 1st, 2027, will be subject to labeling requirements, and added a pathway for labeling exemptions. The board is authorized to adopt rules for testing consumer products. The rebuttal rule provides the ability for the department to test or require a manufacturer to test their products to determine the presence and concentration and to submit that information to the department. Testimony about fees and fee schedules for reporting, CUU designation, and label waiver applications will be provided by Environment Secretary James Kenney, and testimony for the enforcement, compliance, and penalties will be provided by Dr. Kyle Staggs.
We'll now focus on the environmental science of PFAS. Can you tell us broadly about the PFAS family and how their properties influence their behavior in the environment?
PFAS are persistent, mobile, and many have been shown to be bioaccumulative and toxic to human health and wildlife. PFAS are a large family of 14,000 chemicals that vary structurally, which influence the biochemical or biological, chemical, and physical properties when released into the environment. The family contains both non-polymer and polymer PFAS. Within classes, there are many subclasses, which include per and polyfluoroalkyl substances, fluoropolymers, and side chain fluorinated polymers. For clarity, the PFAS Protection Act provides us with a definition. PFAS, quote, means a substance in a class of fluorinated organic chemicals containing at least one fully fluorinated carbon atom, end quote. Much attention has focused on the non-polymer group of PFAA containing the subgroup of PFCA and PFSA because of the well-established detrimental effects of legacy substances such as PFOA and PFOS. Legacy PFAS are in water, soils, and in biological samples, including human tissue, fish, and other foods. Concerns about legacy PFAS has led to newer classes of alternatives, though there are emerging concerns of this new class. Some alternatives, such as PFNA, show higher toxicity across developmental stages in zebrafish and can accumulate in plants and animals in food webs. These alternatives illustrate shared concerns across all PFAS, such as persistence, mobility, and potential toxicity.
Can you please tell us a little more about polymeric PFAS?
The fluoropolymer subclass may not be as inert as originally understood. PTFE is a fluoropolymer commonly used in nonstick pans, and exposure to PTFE microplastics and PFAS can occur with food contact products through regular use. At expected cooking temperatures, PTFE-coated cookware and cooking utensils emit various gases and can contain PFAS. For instance, emissions of PFCA can reach 12,000 nanograms per hour. PFAS are also used during fluoropolymer production and can expose humans through production, use, and disposal of consumer products. Additionally, studies stating that fluoropolymers should be considered, quote,
Excuse me,
polymers.
sir. If you could slow down a little bit and start that new paragraph.
PFAS are also used during fluoropolymer production and can expose humans through the production, use, and disposal of consumer products. Additionally, studies stating that fluoropolymers should be considered, quote, polymers of low concern are authored by representatives from fluoropolymer production companies and contain conflicts of interest statements.
Can you describe how PFAS chain length influences transport through the environment?
Chain length refers to the number of carbon atoms in PFAS and affects movement in the environment. Long chain are typically suspended in particulate matter or in sediments, whereas short chain tend to be in the water column. Long chain can also aggregate on clay particles in soil and increase PFAS soil retention. Long-chain PFOS and PFOA are decreasing in human samples, but increasing in sediments. Short-chain are highly mobile in both soil and water and rapidly contaminate drinking water sources, are uptaken by edible portions of plants, and can bioaccumulate along the food web. In soils, short-chain increase in relative concentration to long-chain with soil depth, and soil contamination is often orders of magnitude higher compared to groundwater. Short-chain migrate through the soil column at faster rates with long-chain, increasing groundwater contamination risks. To make matters worse, treatment removal technologies are less effective at removing short-chain PFAS compared to long-chain, highlighting concerns with these short-chain replacements. All told, it is too early to tell if these shorter-chain PFAS are less detrimental. Further chemistry of PFAS is the subject of Dr. Mitch Olson's testimony.
Can you describe the general sources of PFAS in the environment?
PFAS enter the environment in direct manners from the consumer product manufacturing to disposal pipeline. Sources also include industrial manufacturing operations such as textile and paper coating, metal plating, AFFF or aqueous film forming foams in fire suppression training, and from use and disposal of consumer products. Indirect sources include landfill leachate, wastewater treatment plants, and from land-applied biosolids. From these indirect sources, PFAS can contaminate groundwater and drinking water sources, concentrate in plant and animal tissues, be consumed as food by humans, and be inhaled in dust.
Can you talk about the scale of annual production, management, and disposal of PFAS?
Centralized databases of total PFAS production do not exist. Still, the US EPA estimates that 170 million pounds of fluoropolymers are produced annually in the US. Furthermore, from 2010 to 2019, total production volume of all PFAS in the US ranged from 500 to over 800 million pounds. Precise data are protected confidential business information, limiting the availability of a robust, comprehensive data set of total global production of PFAS. The U.S. Toxics Release Inventory Program monitors the release in the environment of over 800 chemicals, including PFAS. In 2023, over 100,000 pounds were disposed, 1 million were treated, and 300,000 were recycled. Globally, hundreds of millions of pounds are produced every year, and a small proportion of total produced PFAS are disposed of or recycled annually, suggesting large unaccounted masses discharged into the environment.
Let's transition to major sources of PFAS in the environment. Can you start with AFFF?
A significant source of PFAS in the environment is from discarded AFFF. The U.S. Department of Defense has used AFFF to extinguish hydrocarbon fires since the 1970s. AFFF has high concentrations of legacy PFAS in groundwater and are important sources of polyfluorinated substances. These substances may contain precursor or unstable forms of PFAS that undergo transformations in the environment that result in terminal degradation products, or the most persistent versions of PFAS. Thus, AFFF sites are long-term sources of terminal PFAS concentrations.
And what about from consumer products?
PFAS emissions from consumer products represent another significant source of contamination in the environment through the products, production, use, and disposal. PFAS are found in textiles, pesticides, building materials, lubricants, electronic products, and paints. This slide shows average concentration on the left y-axis, number of products on the right y-axis, and product type on the x-axis. Average concentration is depicted as the round circle. The highest concentrations are found in textile finishing agents, household chemicals, oils and lubricants, building materials, and cosmetics. The highest diversity of PFAS is found in textiles. PFAS emissions from cosmetics can be as high as 84,000 pounds per year in Europe, a significant emission source compared with the washing of textiles, which emit around 300,000 pounds per year. Electronic products represent another source in consumer products. Exposure pathways include e-waste handling, processing, and landfilling through inhalation, ingestion, and dermal contact. PFAS are widely detected in water, soil, leachate, and rainwater near e-waste facilities. As a result, PFAS levels are elevated in human tissue samples in those living nearby. Studies have documented immediate and significant declines of contamination at ski areas following consumer product bans on PFAS and ski waxes, showcasing the influence of policy on reducing contamination.
Can you provide us with an overview of PFAS and food systems, please?
PFAS emissions through the production, use, and disposal of a consumer product or from AFFF can negatively impact the food system. PFAS can accumulate through the irrigation with polluted water, contaminated rainwater, and land application of biosolids, increasing PFAS in soil biota, including earthworms. Land application of biosolids can contaminate downstream environments, including groundwater and soil. Every year, the U.S. generates over 7 million dry metric tons of biosolids, and over 50% of these are land applied, contributing an estimated 2,700 to 3,400 kilograms of total PFAS to soils. Levels in soils and groundwater that receive biosolids are 2 orders of magnitude higher than background levels, which can ultimately serve as a reservoir of contamination for edible crops, including fruits and vegetables, and animal products such as meats, eggs, and milk. Pesticides can also be a significant source of PFAS in agriculture. For active pesticide ingredients approved for use in the last 10 years, 30% were PFAS that can be directly applied to crops and soils, endangering surface and groundwater.
Can you talk about plant uptake of PFAS, please?
Yeah, there you go. Plants uptake PFAS through roots and transport them along vascular tissue. There are strong correlations between soil PFAS concentrations and bioaccumulation in plants. Long chain are found in potatoes and cereals, and short chain are found in leafy vegetables and fruits. Up to 5,000 nanograms of PFAS per gram of tissue have been observed in carrots, radish, cabbage, and lettuce near fluorochemical plants. This graph shows PFAS subgroups on the x-axis, concentration in different crops on the y-axis, and chain length in different colors. Short chain are preferentially absorbed by crops since long chain cling to soils. PFAS uptake is particularly high in soybeans.
How does PFAS contamination affect passive receivers such as landfills and wastewater treatment plants?
Landfills receive PFAS waste from biosolids, ash produced from biosolid incineration, PFAS from incomplete combustion during the incineration process, and disposal of consumer products, including paper products, textiles, and carpet. Leachate from landfills is sent to wastewater treatment plants for treatment. However, wastewater treatment plants were not historically designed to remove PFAS, resulting in PFAS re-release into the environment. Despite their phase-out and restricted use in the U.S., PFOA is commonly detected in landfill leachate. Landfills have elevated air concentrations of volatile PFAS, and FTOH is the dominant PFAS in landfill gas with a median concentration of 19,000 nanograms per cubic meter. U.S. landfills produce over 800 kilograms per year of PFAS in landfill gases, which is similar to the 600 kilograms per year in leachate from landfills. Wastewater treatment plants serve as passive receivers of environmental PFAS contamination. They enter wastewater treatment plants from industrial waste, firefighting waste, landfill leachate, and municipal sludge. Globally, wastewater treatment plants have low or even negative removal efficiencies that result in effluent concentrations being higher than influent. In a global study of wastewater treatment plants, researchers found influent concentrations as high as 2,000 nanograms of PFAS per liter, effluent concentrations approaching 5,000 nanograms per liter, and biosolids as high as 500,000 nanograms per gram. Short chain are prevalent in influent and effluent, and long chain are dominant in biosolids. Individual wastewater treatment plants can emit hundreds of pounds of PFAS per year, and ultimately passive receivers spread PFAS contamination far and wide.
Do wastewater treatment plants provide conditions for precursor PFAS transformation?
As I mentioned with AFFF, PFAS are subject to transformation in the environment, and wastewater treatment plants can be sites of precursor to terminal PFAS transformation. The negative removal efficiencies of PFAS in wastewater treatment plants are a result of these transformation processes. This slide highlights precursor to intermediate and terminal product transformations through different matrices and conditions at wastewater treatment plants. Through no fault of their own, wastewater treatment plants passively receive PFAS and can even increase levels released into downstream environments, which is another reason we need to turn off the spigot of PFAS in New Mexico.
How does PFAS contamination impact water?
PFAS are widespread and are circulated through the globe's hydrological cycle. PFAS enter the atmosphere from industrial emissions, dust, and when surface water is aerosolized. PFAS may be redeposited through either wet or dry deposition. Rainwater contains both legacy and emerging short-chain PFAS and can transport PFAS over long distances. Stormwater runoff can also contribute to surface water contamination. PFAS distribution in surface water is widespread. Concentrations can vary up to 8 orders of magnitude and are highest at sites near industrial and manufacturing facilities. And PFAS in urban watersheds can be over 2,000 nanograms per liter or 500 times the EPA limit for PFOA and PFOS. From surface water, PFAS can move to sediment, animal tissue, or groundwater depending on the chain length. PFAS can accumulate in groundwater downstream from wastewater treatment plants, and the air-water interface absorption can control long-chain transport to groundwater. Absorption and transformation can alter the movement of precursors into downstream groundwater. PFAS transformation increases mobility and lowers absorption potential, increasing transport to groundwater. Further, soil microbes can mediate PFAS transformation, which can explain fluorinated intermediaries that are not often measured at contaminated sites. The widespread distribution and movement of PFAS through global hydrological cycle is another reason to turn off the PFAS spigot at its source.
Will you please tell us about PFAS in soil?
PFAS are found in soils globally and cycle through soil microbes, plants, and terrestrial food webs. Soils can be contaminated with AFFF, manufacturing plants, biosolids, and from atmospheric deposition. Hydrogen bonding, hydrophobic interactions, ligand exchange, and electrostatic attraction influence how PFAS move in soil. Electrostatic attraction between positive soil particles and negatively charged constituents in PFAS lead to PFAS soil retention. Soils high in organic matter are negatively charged and can inhibit absorption of anionic PFAS, which results in transport. PFAS movement in surface and groundwater, soils, and sediment is highly dependent on site-specific factors, including soil properties, pH, temperature, and PFAS type. Indirect exposure pathways through soil represent another justification to stem the flow of PFAS into the environment.
Can you please tell us about PFAS in dust?
PFAS distribution in dust is also widespread. Sand and dust storms contribute to PFAS dust generation and are affected by anthropogenic land use, properties of soil, types of vegetation, and climate. Sources include firefighting stations, military bases, and other aviation sites, fluorochemical manufacturing plants, indoor dust in landfills, wastewater treatment plants, and road dust. Landfills can also be a significant source of PFAS dust from discarded products such as carpets. Biosolid generation and subsequent land application can also create dust from PFAS dust from dust storms.
Can you please end with providing context for the importance of the rebuttal rule?
The rebuttal rule reflects a balance between human and environmental health, interested party concern, and statutory mandates. My testimony provides the technical basis for turning off the PFAS spigot at its source. PFAS contamination becomes more diffuse, which leads to challenges with containment and remediation, highlighting the importance of stemming the flow of PFAS into the state. Prohibiting consumer products with PFAS is a practical and technically feasible way to reduce difficult to remediate PFAS contamination, decrease PFAS movement through plants, animals, and humans, and one of the only ways to realistically decrease PFAS exposure. When House Bill 212 passed the New Mexico House of Representatives 62-1, the Senate 37-3, and Governor Lujan Grisham signed the PFAS Protection Act into law, our state leaders took unified and decisive action to protect New Mexicans and our environment from PFAS in consumer products. Adopting the rebuttal rule would implement the PFAS Protection Act and tackle environmental contamination at the source. The rule empowers consumers to learn more about PFAS from a simple Erlenmeyer flask symbol and optional, non-controversial statements of facts disclosing the presence of PFAS. We can turn off the PFAS spigot from consumer products. I respectfully encourage the EIB to adopt the rebuttal rule.
Mr. Smithcare, before you move into rebuttal, I think it'd be good to take a break.
Thank you, Madam Hearing Officer.
Were you about to do that?
Take a break?
No, move into rebuttal.
I was.
Okay, let's take 15 minutes and come back at 10:50. Alrighty, we are back after a short break. Dr. Chapman has returned to the witness seat, and Mr. Smithcare, I believe you're about to lead him through his rebuttal testimony. You have 15 minutes.
Thank you, Madam Hearing Officer. Dr. Chapman, how does your direct testimony relate to your rebuttal testimony, and what is the purpose of your rebuttal testimony?
Do we have the slideshow going?
Oh, it's on my screen. Let me.
Just as a court reporter, I would just ask that you remind the witnesses to read slowly.
Thank you very much, David. And yes, please.
Is the slideshow sharing?
Is he able to share?
Counselor, I don't see you on the WebEx platform anymore.
Okay, I'm showing on the WebEx platform. Maybe I'll log out and log back in.
I see him on. He's on.
Okay, Counselor, you should be able to get in now.
He's present.
Sorry about that. Dr. Chapman, how does your direct testimony relate to your rebuttal testimony, and what is the purpose of your rebuttal testimony?
The overall message of my direct testimony was that the full environmental impact of a consumer product with PFAS must consider PFAS emissions from production, use, and disposal. The purpose of my rebuttal testimony is to provide the board with an overview of revisions in the proposed rule since filing on January 16th, and to address environmental science claims in the direct written testimony provided by the Complex Products Manufacturers Coalition, or CPMC, and the American Chemistry Council.
Has the department continued to engage with interested parties?
Yes, engagement has continued leading up to the rulemaking hearing, which shaped important revisions in the rebuttal rule. Most notably, the department removed language about health and environmental effects on the proposed label and removed a link to the department's website. The rebuttal rule proposes to require a symbol of an Erlenmeyer flask with the word PFAS inside. Directly adjacent are optional, non-controversial statements of fact, such as made with PFAS or contains PFAS. This label revision honors the statutory definition and simply states whether a consumer product contains PFAS.
Did you review the technical testimony of Dr. Stanton and Ms. Marapese?
Yes.
Did you identify any inaccuracies with their direct written testimony?
Yes.
Can you please describe for us the inaccuracies that you identified?
Overall, Dr. Stanton's testimony is sparse, overly general, and ignores environmental realities. Most glaringly, this testimony ignores that PFAS emissions from consumer products occur from product manufacturing, use, and disposal. The brief testimony argues that as a class, PFAS are not harmful, and quote, nor that they are forever chemicals, end quote. First, this downplays the common phrase in the popular press with the biochemical reality that PFAS are subject to degradation and are not truly forever. This also acknowledges that PFAS are subject to environmental transformation, which may lead to the generation of particularly harmful PFAS. Additionally, PFAS as a class do have shared characteristics such as persistence and varying levels of mobility, which contribute to environmental concerns. Dr. Stanton adopts a narrow view of environmental release of PFAS from fluoropolymers. Dr. Stanton states that, quote, fluoropolymers are an entirely separate entity, end quote. As defined by statute, fluoropolymers are PFAS. The claim that insolubility in water means that they cannot contaminate the environment is false. Think of microplastics, for instance, and it shows that polymeric PFAS persist in the environment. It also ignores that another polymeric PFAS, side chain fluorinated polymers, can transform into the persistent group of PFAA. Finally, fluoropolymers can also emit PFAS, such as the highly persistent and mobile trifluoroacetic acid, or TFA, during thermal processing and incineration. High thermal stability and insolubility in water are not magical properties that exempt fluoropolymers from contaminating the environment. Dr. Stanton's testimony also ignores that PFAS emissions from fluoropolymer production contaminate the air, soil, and water. The European Chemicals Agency proposes to restrict all PFAS, demonstrating that there is sufficient concern to regulate PFAS as a class, contradicting Dr. Stanton's testimony. Dr. Stanton's discussion on labeling of complex durable goods contains various inaccuracies. First, the rebuttal rule does not require the vehicle to be labeled, only the owner's manual. Second, Dr. Stanton ignores that complex durable goods with internal components can contain consumer-facing PFAS, such as vehicle seats. Third, the label provisions in the rebuttal rule do not, quote, communicate hazard, end quote, as she states. The proposed labeling program provides consumers with a simple symbol so a consumer can choose to bring that product into their home. Finally, Dr. Stanton states, quote, requiring all PFAS containing products to include a label suggesting that they pose such risks is inaccurate, or at the very least, the subject of ongoing scientific research and debate, as even the fiscal impact report to HB 212 acknowledges, end quote. One can see that given a more thorough reading, the proper interpretation of the fiscal impact report to HB 212 is that there is no level of exposure to PFAS that can be considered safe. Like Dr. Stanton, Ms. Marpese attempts to minimize the environmental risks associated with PFAS in consumer products. Ms. Marpese generalizes across all complex durable goods that components are sequestered inside, removed from consumer exposure, and safe from environmental release. This assumes that all PFAS are only contained in internal components. This also completely ignores environmental contamination pathways from production to disposal of a product. Electronic waste can be a significant source of PFAS emissions into the environment, leading to the contamination in water, soil, leachate, human blood, and rainwater. As an example, recycling emissions from vehicles can be as high as 5,000 micrograms of PFAS per kilogram of vehicle residue, and stormwater related to vehicle recycling can emit 520 nanograms of PFAS per liter of water, which is over 100 times higher than the EPA drinking water standard for PFOA and PFOS.
Did you review the technical testimony of Dr. Korzanowski?
Yes.
Did you identify any inaccuracies in his direct written testimony?
Yes.
Can you please describe for us the inaccuracies that you identified?
The direct testimony from the American Chemistry Council makes erroneous claims that the department treats all PFAS the same, narrowly focuses on polymers, and ignores PFAS emissions throughout a product's life cycle. The three-page direct testimony of Dr. Stephen Korzanowski, an organic chemist for PFAS manufacturer DuPont for the majority of his career, claims that the proposed rule treats all PFAS the same. First, it is clear from the exemptions provided in the PFAS Protection Act that not all PFAS are to be treated the same. Some consumer products are prohibited in 2027, some in 2028, some 2032, and some are exempt altogether. In fact, there are 16 enumerated exemptions provided by statute. Second, there is a pathway for currently unavoidable use of PFAS. Third, the proposed labeling provision in the rebuttal rule is not a warning label, and labeling all consumer products does not imply that all types of PFAS present similar concerns. It is merely a statement of fact and information that consumers can choose to incorporate into their purchasing decisions, use of the product, and disposal. Dr. Korzanowski's testimony provides a short 6-point list to somehow show that, quote, all PFAS are not the same, end quote. Dr. Korzanowski claims that fluoropolymers are of low concern. First, low concern is not no concern, and this ignores that fluoropolymers released into the environment still constitute environmental PFAS contamination. At the very least, this represents a source of highly persistent contamination as a reservoir of fluoropolymer degradation products. Like CPMC, Dr. Korzanowski ignores that side chain fluorinated polymers can degrade into non-polymeric PFAS. PFAS exposure and environmental release occurs throughout the production of PFAS polymers, manufacturing of products with PFAS polymers, the use of the product, and waste and recycling of the product. The European Environment Agency states, quote, although the synthesis of PFAS polymers takes place in closed systems, evidence shows that emissions of non-polymeric PFAS can occur all along the life cycle. They can be emitted at all stages, from ingredient production to producing the polymer, from reshaping it into a product to the product's use, from its recycling or reuse of the product to its disposal by landfilling or incineration. The resulting pollution has spread widely and has accumulated in water, air, soil, people, biota, and food, end quote. Dr. Korzanowski's selective focus on the risk of PFAS from fluoropolymers does not paint the whole picture. This ignores that non-polymeric PFAS is used for the production of polymeric PFAS, including fluoropolymers.
Excuse me, sir. This ignores non-polymer PFAS is used. Continue slowly.
For the production of polymeric PFAS, including fluoropolymers, and that fluoropolymers emit the highly persistent and mobile ultra-short chain TFA during thermal processing and incineration. The rebuttal rule, my direct testimony, and the testimony of other department experts will illustrate that not all PFAS are the same.
I'm sorry, it's advancing on my computer, but not on the screen.
Oh, you mean you forwarded the slide?
Yeah, like I advanced to the next slide, which he's waiting for, and it's not advancing on the platform.
I'm not sure. Oh, there it is.
Please continue.
Dr. Korzanowski quotes the Chemicals and Biotechnology Committee of the Organization for Economic Cooperation and Development, or OECD, stating, quote, The term PFAS is a broad, general, non-specific term which does not inform whether a compound is harmful or not. End quote. The department does not rebut this beyond disagreeing that this somehow proves that the department treats all PFAS the same. Further, OECD also released a synthesis report on understanding fluoropolymers and their life cycle in 2025. They stress the importance of considering, quote, fluoropolymer production, use, degradation, and environmental emissions, including the role of polymerization and processing aids, end quote, illustrating a commitment to adopting a life cycle assessment approach. The very organization that Dr. Korzanowski cites to claim that the department treats all PFAS the same refutes this narrow and simplistic perspective in his testimony. It is the department's view that not all PFAS are the same. Dr. Korzanowski's testimony references a report from Vermont's Department of Environmental Conservation that considers managing PFAS as a class and erroneously interprets their findings. The decision not to regulate PFAS as a class by Vermont was not made because the science absolved regulating PFAS as a class, but because of financial, resource, and data sampling limitations. A few select quotes from the report. Quote, "The state of Vermont does not have the resources," end quote. And, quote, "As a result of this lack of information, the Agency of Natural Resources is not, at this time, recommending that PFAS be more broadly regulated as a class," end quote. Following this report, Vermont's DEC released a PFAS roadmap where they highlight Vermont Act 36, which prohibits PFAS as a class in consumer products. Finally, Dr. Korzanowski quotes a congressional report from the Department of Defense. The department does not rebut the spirit of the quote beyond disagreeing that this somehow proves that the department treats all PFAS the same. In fact, the quote is an endorsement of the CUU process, and the rebuttal rule seems to align with DOD's perspective, contrary to what Dr. Korzanowski claims. Dr. Korzanowski is narrowly focused and fails to even acknowledge exposure pathways beyond direct consumer product use.
Sorry.
I'm not sure I have an explanation for that. Oh, there it is.
Please continue.
Okay. The testimony I rebut makes narrow, inaccurate, and unsubstantiated claims. They argue that the department treats all PFAS the same, ignoring product exemptions, COUs, and pathways for labeling exemptions. They narrowly focus on fluoropolymers and ignore that PFAS emissions occur during PFAS production, consumer product manufacturing, product use, and product disposal. PFAS transform in the environment, resulting in indirect exposure pathways in the air, dust, water, and soil. One could argue that the testimony for ACC and CPMC treat all PFAS the same, that all PFAS is of low concern, that PFAS exposure results only from direct consumer contact with a product during use. You can ignore PFAS emissions during a product's life cycle, and the department should not propose labeling requirements on consumer products containing PFAS. The department has engaged in good faith collaborations with interested parties, resulting in the rebuttal rule for the EIB's consideration. It is my hope that the board adopt the rebuttal rule to turn off the PFAS spigot from consumer products. Requiring simple labels on consumer products will allow consumers to choose whether they purchase products containing PFAS. Help New Mexico empower consumers' choice to reduce their exposure and environmental release by adopting rules for PFAS labeling. Turning off the spigot today will help relieve the long-term burden faced by our state's largely rural infrastructure that provide New Mexicans with clean and safe water.
Thank you, Dr. Chapman.
Thank you, Mr. Smith-Care. We will move to questioning of Mr. Smith-Care. Mr. Molenberg, would you like to go first?
Madam Hearing Officer, I'll be doing the questioning.
Oh, all right. Thank you, Mr. Trujillo. Go ahead.
Dr. Chapman, before we begin, do you have access to your direct and rebuttal testimony? I think it's NMED Exhibit 3 and Exhibit 71. Do you have those before you?
I do.
Okay. I'm going to be referring to those. So just in case you want to follow along or need to refer to your testimony, I want to make sure you had the documents.
Appreciate that.
Good morning, Dr. Chapman.
Good morning.
I want to ask you some questions first, dealing with the general framework of the overall rule and general framework of PFAS also. So let's start there, and I'm going to bounce around because I only got 30 minutes and you have a lot of testimony. So I'm going to try to pick out the relevant parts that I think are important to highlight.
Okay.
In NMED Exhibit 3, your direct testimony at page 44, you state there are over 14,000 chemicals that are classified as PFAS by the U.S. Environmental Protection Agency. Is that correct?
Yes.
Then now turning to NMED Exhibit 3 at page 6 to 7, you state one of the many catalysts for states' actions regulating PFAS, including New Mexico's PFAS Protection Act, is the bioaccumulative, persistent, and toxic nature of many PFAS. Is that correct?
Yes.
So you are not saying that every PFAS is bioaccumulative, persistent, and toxic in nature, correct?
I'm not.
When you say that many PFAS are bioaccumulative, persistent, and toxic in nature, what percentage of the over 14,000 chemicals classified as PFAS by the EPA are bioaccumulative, persistent, and toxic in nature? Would you estimate?
I'm not aware of any data that speaks to percentages.
Do you have a guess?
I don't feel that is in the scope of my expertise.
Okay, I'll move on. Thank you. So would you agree with me that New Mexico's PFAS Protection Act will prohibit the sale of certain PFAS that are not bioaccumulative, persistent, and toxic in nature?
The PFAS Protection Act prohibits certain groups of consumer products.
Correct. And maybe let me ask my question again. Maybe you missed what I was asking. Would you agree with me that New Mexico's PFAS Protection Act will prohibit the sale of certain PFAS that are not bioaccumulative, persistent, and toxic in nature?
Let me restate what I previously said, and that the PFAS Protection Act prohibits certain consumer products that contain various PFAS types.
Are any of those products not bioaccumulative, persistent, and toxic in nature?
Can you repeat the question?
Are any of those products you referenced that were prohibited under the New Mexico PFAS Protection Act, are any of them not bioaccumulative, persistent, and toxic in nature?
Yes.
And likewise, the revised proposed rule that you referenced would require labeling of products containing certain PFAS that are not bioaccumulative, persistent, and toxic in nature, correct?
The rebuttal rule
Correct.
proposes labeling all PFAS that are statutorily defined by the PFAS Protection Act.
And would some of those products be required to be labeled even though they're not bioaccumulative, persistent, and toxic in nature?
If they are PFAS by the statutory definition, yes.
Dr. Chapman, let's move on to, and you heard I think you were in the room, you heard some of my arguments on notice issues, and I'm going to delve into that a little bit with you. And if you're not the right witness, let me know, and I can reserve some of those questions for someone else.
Sounds good.
Dr. Chapman, your direct testimony in NMED Exhibit 3 at page 11 indicates that on December 23rd, 2025, New Mexico published an advertisement in the New Mexico Register that provided the public with notice of three things. Is that correct?
Can you restate the page in my testimony?
It is page 11 of your direct testimony.
And what passage were you referring to?
Passage where you talk about the advertisement in the New Mexico Register.
Okay. What was the question?
You indicated that you published an advertisement in the New Mexico Register that provided the public with notice of three things, and you outline them, 1, 2, and 3. I'll actually read the three things to you to help refresh your memory. Number 1 is NMED's proposed rule. 2, the dates and times of the hearing. And 3, the procedures for public comment on the proposed rule. Is that correct?
I'm sorry, I still haven't found the passage in my testimony. Page 11?
Yes, page 11. The very top, see
Oh,
where
sure,
it says New
yes.
Mexico Register? Starts the very top paragraph, NMED published. Are you following me now?
Yes.
And the three things, again, that you mentioned were NMED's, the three things that you put everyone on, the public on notice of was the proposed rule, the dates and times of the hearing, procedures for public comment, and on the proposed rule, correct?
Yes.
Are you aware that the State Rules Act required NMED's public notice set forth in the New Mexico Register to include a citation to technical information that served as the basis for the proposed rule and information on how the full text of the technical information may be obtained?
Yes.
As set forth in the public notice in English identified in the docket for this matter, you attempted to comply with the State Rules Act by stating the following information relevant to the technical information requirement. What the notice said that was provided in the docket is, quote, technical information that served as the basis for the proposed rule may be viewed online at https://www.env.nm.gov/public-notices and may also be obtained from the petitioners upon request. And then it gave a place where you could email. Is that correct?
Yes.
If one were to go click on the link to find the technical information that served as the basis for the proposed new rule, one would have found a list of 19 publications with citations. Is that correct?
I believe so.
Who put together this list for NMED?
The HB 212 internal team.
And who did that consist of?
Myself, Mr. Smith-Keir, and trying to refresh my memory. Who else was there? That's all I can recall at the time.
As far as you can recall, two of you, you and your attorney, is that correct?
I believe so, but I think I'm not remembering everybody.
Okay. And how did you go about deciding those 19 publications?
A few of those publications provided human health rationale for the rules. A few provided environmental science pieces, and others spoke to certain aspects of testing. So.
And why were these ones the most important?
We are petitioning the EIB for them to adopt rules prohibiting PFAS in consumer products. And some of the strongest justifications for that are because of human and environmental health concerns.
And you felt those 19 best explained those concerns?
I would say that served as a basis. And the matter of this hearing is to provide a fuller extent of the testimony that justifies these proposed rules.
Let's turn to, back to your testimony, and this time, let's turn to page 75, and you can skim through to 91. And I'll represent it, the material on those pages represents that you're citing to 113, if I counted things correctly, references dealing with publications to support your testimony. Is that correct?
Yes.
Approximately when did you start identifying and reviewing these 113 publications?
As a part of producing my written testimony for this hearing, I conducted a literature review basically as soon as I was hired.
And when were you hired?
August of 2025.
So you have been accumulating at least a portion of these articles, if not all of them, starting in August of 2025. Is that correct?
Yes, since my employment at the department.
And why did you decide not to include all of these if you had already started to accumulate them in August of 2025? Why didn't you include them in your December 23rd, 2025 notice in the New Mexico Register?
I cannot speak to how many at each month I had in terms of finding, reading, digesting, analyzing. So our technical basis provided a broad framework for environmental issues concerning PFAS.
So between August 2025 and December 23rd, 2025, you did have additional articles other than the 19 that were listed in the public notice. Is that correct?
Can you restate the question?
So between August 2025, when you were hired, and December 23rd, 2025, when the New Mexico Register public notice went out for this rulemaking, you had articles and publications that you thought were relevant in your hand during that time frame, correct? Beyond the 19 that were in the public register.
My analysis of the literature, I can't speak to numbers of articles during each month, but my literature review on environmental effects of PFAS began in August.
And when did it conclude?
The filing deadline for technical testimony on January 16th.
So between December 23rd, 2025 and the filing deadline, which was about what, a month for your technical testimony? About a month, is that correct?
I believe so. 3 weeks.
3 weeks?
Yeah.
So in those 3 weeks, were you continuing to accumulate publications?
In what, 3 weeks?
In the 3 weeks between December 23rd and the date that you had to file your technical testimony?
Yes.
How many would you estimate that you continued to find during that time period?
I have no way to estimate that number.
Less than 20?
I'm not sure.
You don't have any guess whatsoever?
I don't want to guess.
How long does it take you to review on average and analyze one of these publications?
That varies greatly.
On average, do you have any guess?
No.
Thank you, Dr. Chapman. On that topic, let's move on. Talk about the topic of meaningful engagement with the public, as I think you described it in your direct. In addition to claiming that NMED provided all legally required notices at page 11 in NMED Exhibit 3, I noticed on page 18 that you also assert any NMED engaged in additional engagement beyond minimum requirements. Is that correct?
Yes.
What was the most common problem raised with the labeling requirements in this additional engagement?
I'm sorry, I'm not following how this relates to the other matter. The
As a part of, let me rephrase the question to see if that'll help you. As a part of this engagement with the public, what was the most common problem raised with the labeling requirements when they were initially published?
Are you speaking to our engagement with interested parties?
Correct.
The most common argument during those revisions focused on the environmental and human health effects that were proposed to be a part of the label.
Was there a second most common problem that you, beyond what you just said, raised during the disengagement dealing with the labeling requirements?
I highlighted that in my summary today, and I believe that the second most common concern was a citation to our website.
And that issue was addressed, correct?
Correct.
In your testimony, in Exhibit 3 at page 18, I noticed that NMED conducted peer-to-peer outreach with other jurisdictions that have similar programs. Do you recall that testimony?
Yes.
I'm going to speed things up here about halfway through. What states have programs that are most similar to the program being proposed in New Mexico today?
Can you clarify what you mean by most similar?
Is there anyone that's the same?
Again, clarify what you mean by same.
So you reached out to other states, correct?
Yes.
Out of those states that you reached out to, does any of those states have the exact same statute as New Mexico has?
Are you talking about consumer product prohibitions with PFAS?
Yes, we'll start there.
I would say Maine and Minnesota.
How many other jurisdictions did you communicate with?
However many I listed in my direct testimony.
Maybe I missed that. You don't recall a number off the top of your head?
I don't want to guess. Maybe 5.
When you communicated with these other 5, we'll call them 5 right now, other jurisdictions, did any of these states report difficulties dealing with PFAS containing products currently lacking readily available PFAS-free alternatives?
Not to my recollection.
Did any of these states report difficulties with tracking PFAS across all components and tiers of international supply chains for any products?
Not that I can think of.
Did any of these states report to you supply chain issues in general domestically?
The most parts of the conversations that I recall with other states focused on building capacity to manage the implementation of these programs.
Thank you for that answer. You took away one of my questions. So staffing or the amount of resources to enforce these similarly situated programs was an issue that was raised?
I would not characterize it as an issue, but just collaborating with other states to figure out best ways to implement these rules and programs.
So none of the states said that they faced significant resource limitations dealing with staffing, funding, or technical capacity to evaluate hundreds, if not thousands of products that are being impacted by this program?
I believe Maine mentioned they have a small staff.
And how big is Maine's staff? Do you have any ideas on that?
I don't know for sure.
Let's move on to labeling. In NMED Exhibit 3 at page 26, you state the most notable element of the revised proposed rule, at least on the national level, is section 20.13.2.13, which instructs manufacturers of products containing intentionally added PFAS to label products as such, including consumer products exempt from the sales prohibition. Do you recall making that statement?
Yes.
You, in particular, referenced the national level in that statement, correct? That statement I just read to you said at least on the national level.
Yes, I made that statement.
So my question for you is New Mexico the first state to adopt this broad of a labeling requirement?
New Mexico's proposed labeling requirement is unique in the symbol. However, states such as Connecticut and Colorado have language with respect to explicitly stating whether a product has PFAS.
Was there a reason for the different symbol?
Could you clarify what you mean?
I believe you said that New Mexico is unique because the symbol is different than those other jurisdictions.
I don't believe those other jurisdictions use a symbol.
Okay. So it goes back to my question, why did you decide to pick a symbol and that particular symbol?
I think you'll hear more about that from other experts that the department will be providing.
You know which experts, so I can make sure I mark on my notes who to come back to?
Dr. Deb Dickerson.
Thank you. With respect to labeling, Dr. Chapman, let me ask you this. Isn't it true that the authorization for this board to label products is a discretionary, not mandatory authority, correct?
That is true. And House Joint Memorial 3 sort of clarifies the legislative intent there.
Well, let's talk about legislative intent. I'm glad you raised that. Are you familiar with the legislative process? Have you lobbied on behalf of a bill or advocated on behalf of a bill?
Objection. Outside the scope.
Mr. Trio?
Madam Rosser, he raised the issue of House Joint Resolution 3, is that right?
Yeah.
Okay. Ask the question again.
Are you familiar, so I'm trying to establish a foundation, Madam Hearing Officer, are you familiar with the legislative process and how it works?
I think I need you to be more specific.
Do you know the significance of a House Joint Memorial?
I would say superficially.
And what is your understanding?
It's a bill that was sponsored by the minority whip or majority whip, excuse me. And it underwent various committees. It received a floor vote and then same sort of process within the Senate.
Well, let me ask you this question. Maybe we can expedite things here due to time constraints. Are you familiar or were you around when the original underlying bill, the act, was passed?
I was employed since August, so no.
Okay. Do you have any knowledge of the fact that the original bill introduced when the PFAS Act originally passed? Do you have any knowledge that the original bill did not contain any kind of language dealing with labeling?
I'm unaware of that.
Dr. Chapman, isn't it true that NMED has already changed its approach to labeling twice since the original proposed rule was presented?
Yes, and it illustrates our commitment to working with interested parties and hearing concerns.
So there've been a total of actually 3 different approaches to labeling. If you count the original, then 2 more revisions, is that correct?
Yes.
On page 16 of your rebuttal testimony, if you want to take a look at that. I believe you, while you're getting there, I'll give you the question and you're going to wait. Are you there?
I believe so.
You criticized Dr. Korzanowski's testimony for not addressing the revised proposed rule when at the time of Dr. Korzanowski's direct testimony, he only had the original rule language on which to comment. Isn't that correct?
Yes. It was a statement of fact that his testimony wasn't based on the most current version.
Dr. Chapman, in reference to your use of the term consumer products during your testimony, was that a defined term under the Act, the PFAS Protection Act?
I could check. I know it's in the rule, but I'm not sure about 212.
I mean, just for a quick time check.
Yes, sir, you have, let's see, 40, 55, 17 minutes left.
Oh, we get the full 45 with the rebuttal. Sorry, I thought I had 30, Madam Hearing Officer. Let me go back to my original questions. Thank you. Let's, going back to your direct testimony, I'm going to now ask you some questions related to, I believe it was part 2 that you labeled the environmental science of PFAS. Is that correct?
Yeah.
But could I return to page 42? So you claim you analyzed, summarized, and interpreted results of over 100 peer-reviewed journal articles to provide a high-level picture of the state of the science of PFAS in the environment, correct?
Yeah.
Can you give us an idea on the total number of peer-reviewed journal articles that provide what you would say the state of sciences of the PFAS in the environment?
No.
Hundred, thousands, no idea?
No.
Okay. How many peer-reviewed journal articles did you disagree with and decline to put into your state of science of PFAS in the environment as you described in your testimony?
Can you clarify what you mean by disagree?
Was there any peer review articles that you reviewed as a part of your analysis that you disagreed with?
I don't know how to answer that question.
I could have a sec to confirm my co-counsel. I could just maybe cut out some questions here. Dr. Chapman, I won't remake you go to page 44 and but what I mentioned it earlier, and that was that you had indicated there are over 14,000 chemicals that are classified as PFAS by the US EPA, correct? Remember that?
I do.
Out of these approximately 14,000 chemicals classified as PFAS, how many of these chemicals would you estimate are covered in your summary of the state of the science of PFAS in the environment?
I don't know how to answer that.
Let me ask you this question then. Are you aware of a published paper in 2021 showing that there were hundreds, not thousands, of these chemicals in actual commerce?
I am familiar with the number, generally is in the several hundreds, yes, but not that particular study.
Dr. Chapman, would you agree with me that your testimony largely relied on data specific to, so I get this right, I'll also give you the abbreviation, perfluoroalkyl acids, or PFAS?
I believe as I stated during my summary of my testimony, that group has been of particular focus.
Dr. Chapman, let's move on, talk a little bit about risk communication issues. In NMED Exhibit 3 at page 44, you state this family of fluorinated organic compounds. You see where I'm at on page 44?
I don't. Is this top, middle, bottom?
I'll go find it myself. My notes indicate that it is page 44. It would be the second complete paragraph, and it starts with within this family. See what I'm talking about?
Yes.
Why don't you just go ahead and read this paragraph for us, because I'm going to ask you several questions here. We're going to read it out loud so you're familiar with it, because I got, again, several questions. I want to make sure you're familiar with the entire context.
You would like me to read it out loud?
Yes, please.
Within this family of fluorinated organic compounds, there is wide variation in chemical structure, which can ultimately influence biological, chemical, and physical properties when released into the environment. Within the family, there are two classes, non-polymers and polymers. Within classes, there are many subclasses, which include perfluoroalkyl substances, polyfluoroalkyl substances, fluoropolymers, polymeric perfluoropolyethers, and side chain fluorinated polymers. For the sake of my testimony and this rulemaking hearing, the PFAS Protection Act provides us with the following definition, quote, per or polyfluoroalkyl substance means a substance in a class of fluorinated organic chemicals containing at least one fully fluorinated carbon atom, end quote.
So in this paragraph, Dr. Chapman, it seems to me as I read your testimony that you indicated you're trying to point to the statutory definition because it's different than something else. Is that correct? Am I interpreting your paragraph here correctly?
I don't agree with that.
Why was it important to point out the statutory definition specifically in this paragraph?
Statutory definitions are important to provide context.
Are there non-statutory or scientific definitions of PFAS?
Can you repeat the question?
Are there non-statutory or scientific definitions of PFAS?
Yes, I would imagine so.
Dr. Chapman, isn't it true that the structure-based statutory definition of PFAS that captures all substances with at least one fully fluorinated carbon does not align with the scientific method of defining PFAS?
I disagree.
Would you agree or disagree with me on this? Scientific conclusions relating to PFAS do not automatically extend to all PFAS containing products, correct?
Yes.
Dr. Chapman, and let me have you turn to page 46 of Exhibit 3. Are you there?
Yes.
On page 46, you state beyond PFOA and PFOS alternatives, there is growing scientific evidence that the fluoropolymer subclass of PFAS may not be as inert as originally understood. Is that correct?
Yes, I wrote that.
And your best attempt to discredit these studies dealing with fluoropolymers is to point out conflicts of interest by authors, correct?
No,
Did you point that out?
I did.
I'm going to ask you some questions outside of the line of my outline here, because there's some additional comments that you made. So I'm going to ask you some questions on various topics. If the department does not treat all PFAS the same as you previously indicated in your testimony, your verbal testimony today, why is it requiring PFAS labeling for all PFAS, including the exemptions?
That is the matter of testimony from Dr. Deb Dickerson and also the department's perspective that labels inform consumers.
But it was your testimony, though, that, or a critique, was that the department treats all PFAS the same, or does not treat all PFAS the same.
I
Is that
was
correct?
rebutting the claim that we did.
And you still maintain that?
Correct.
Dr. Chapman, NMED's, as you stated, NMED's purpose of the proposed rule is to turn off the spigot of PFAS at its source. Is that correct?
Yes.
Does the department intend to discourage manufacturers of PFAS containing products from distribution into Mexico?
Objection, outside the scope.
Madam Hearing Officer, as the witness indicated, I believe it goes into the policy choices they made. He's testified extensively on various policy choices.
Dr. Chapman, can you answer the question within the scope of your earlier testimony?
Can you repeat the question?
Absolutely. As you testified earlier, NMED's purpose of the proposed rules to turn off the spigot of PFAS at its source. Is that correct?
Yes, in my testimony, I provided that consumer products are one avenue of sources of PFAS in the environment.
So as a part of that, are you intending to discourage manufacturers of PFAS containing products from distribution into Mexico?
I believe there's pathways for the continued distribution of products containing PFAS to operate under currently unavoidable use proposals. And there are exemptions as well.
I don't remember if I asked you, how long, in these other states that you talked to, did any of them indicate how long it takes to get a unavoidable use determination on average?
No.
Do you have any ideas how long it's going to take in New Mexico? Have you guys estimated that at all?
No.
Dr. Chapman, are you aware of any PFAS manufacturing within New Mexico?
I don't know. I'm not sure.
Have a time check.
I was about to tell you, you have about 3 minutes now.
Thank you, Madam Hearing Officer. In the remaining time we have, Dr. Chapman, in your direct testimony in Exhibit 3, you discussed general sources of PFAS in the environment, pages 51 to 52. As a part of this discussion, you then touch upon the following topics: PFAS production, management, and disposal at page 52 to 53, PFAS from AFFF foam at pages 53 to 55, PFAS from consumer products, accumulation of PFAS in food from agriculture, and PFAS in landfills. Is that correct? There's a long section you included discussing those topics, correct?
Among other things, yes.
If I understand your testimony, you admit that robust and centralized databases of total PFAS production do not exist, correct?
That's what I stated, but that doesn't mean that there aren't estimates, which I provided today.
Dr. Chapman, if I understand your testimony in that long section, consumer products only contain some forms of PFAS classes and subclasses, not all PFAS classes and subclasses, correct?
Can you repeat the question?
If I understand your testimony in these sections that I referenced, consumer products only contain some forms of PFAS classes and subclasses, not all PFAS classes and subclasses, correct?
I'm not sure about that.
Why aren't you sure?
Because there's lots of different consumer product types.
So you just don't have the available, that information isn't available.
Not that I'm aware of.
Madam Hearing Officer, I think I'll conclude at that point because I think I have about 30 seconds left.
That's correct. Thank you very much, Mr. Trujillo.
Thank you, Madam Hearing Officer.
Alrighty, we are going to return at 1 p.m. And when we return at 1 p.m., we're going to invite some public comments. I've got 3 or 4 folks already indicating an interest. And of course, I'll issue a general invitation. See you at 1.
Oh, come on.
All right, good afternoon. My name is Felicia Orth, the hearing officer in the hearing on PFAS. This is docketed as EIB 25-61. We're on day 1 of the hearing and have reached our first public comment period. Just a few things about public comment. I will ask you to state and spell your first and last name. I will ask you to swear or affirm to tell the truth, pursuant to the board rulemaking rules. I will ask you to keep your comments to 3 minutes or less. In the event you have more to say by way of input on this rulemaking, please know that you may submit as lengthy written public comment as you would like. You would send that to Pamela Jones, whose information is in the public notice. We do have a court reporter capturing your every word, so I will ask you to be sure to speak slowly. We also have interpreters between English and Spanish and English, also capturing your every word. Ms. O'Grady.
Sí, buenas tardes. Si hay alguien aquí presente en la sala de audiencias que quisiera hacer un comentario público, si nos pueden dejar saber, por favor. And if there's anybody here present in the hearing room that would like to make a public comment, if you could please let us know. Y también para los que están participando remotamente, si nos pueden avisar si quieren hacer su comentario público en español. If you're online and would like to make your public comment in Spanish, if you could please let us know, you can do that in the chat. Nos pueden dejar saber en el chat.
Thank you, Ms. O'Grady. So I'm going to invite the folks in the room first who have been here this morning with us in the order in which I see your names on the sign-in sheet. Again, I'll ask you to collect your thoughts. I can only call on you once. And if you're not ready, I will call on you again at a different public comment period. We expect to have several of them at 1 o'clock each day that we're in hearing. So let's begin with Andrew Bemis, I believe. Andrew Bemis. Oh, hello. Yeah, if you would come up to our witness stand over there. If you would please state and spell your first and last name.
Sure, that's Andrew Bemis. I can't hear, Judge.
Oh, is your mic on?
Is that work?
Yes.
Good.
Thank you.
Andrew Bemis, that's Andrew Bemis, Bemus.
Right. Do you swear or affirm to tell the truth?
I do.
Thank you. I'll start your time.
Thank you. Thank you for the opportunity to testify today. Thank you to the board and members of the Environment Department who are here today. I am representing the Sustainable PFAS Action Network, a coalition of PFAS users and producers committed to sustainable risk-based PFAS management.
Slow down a little.
Sure. SPAN supports many aspects of HB 212 and the proposed rules, such as its careful consideration of essential uses and critical aspects of New Mexico's economy. However, certain provisions of the proposed rules, particularly the unmandated labeling requirement, should be reconsidered to make New Mexico's PFAS in products program more effective and aligned with the statute. SPAN would like to emphasize that the inclusion of a labeling requirement for almost all PFAS-containing products sold in New Mexico undermines the intent of HB 212 and threatens the successful implementation of the law. HB 212 does not require labeling. It states that the department may implement a labeling requirement without providing any further guidance. Critically, the proposed rules do not automatically exclude from the labeling requirement the various uses listed in HB 212 that the legislation exempts from the notification requirements and product sales prohibitions. While manufacturers involved with these uses may apply for a waiver, the requirements for a waiver application are onerous and are similar to the reporting requirement that HB 212 sought to exempt these uses from. This will almost certainly lead to implementation issues that will delay the primary work of the New Mexico Environment Department. SPAN strongly urges that the Environmental Improvement Board encourage the department to postpone the labeling rules and to instead prioritize implementing the regulations that are mandated by statute, as several other elements of the rules require attention before labeling is considered. SPAN would also like to emphasize that the proposed compliance date of January 1st, 2027 for product labeling is not feasible, especially if the rules are not expected to be finalized until the end of this summer. If the labeling requirement moves forward, SPAN strongly recommends that the labeling requirements do not apply to those products which are specifically exempt from restriction and reporting by subsection A of Section 3 of the PFAS Protection Act. If the rules move forward, several improvements must be made in order for the implementation of the PFAS Protection Act to be successful. For example, currently unavoidable use submissions are required to include extensive data that is not available at the product level. SPAN encourages the department to follow the lead of the federal government and require CUU requests to contain only what is known or reasonably ascertainable. SPAN would also strongly recommend that products containing PFAS at a concentration below or at 1% and products used exclusively for research and development purposes be exempt. To reiterate, SPAN encourages reconsideration of the proposed labeling requirements to, at a minimum, automatically apply the exemptions from subsection A of Section 3 of HB 212. If the Environmental Improvement Board recommends that the labeling requirements proceed, the department must consider several changes. For example, as previously stated, SPAN recommends a minimum concentration threshold should be reached to establish that labeling is required. It is also important that manufacturers have a choice to place the label on either the product or its packaging, as that may be the most feasible place to place the label. Clarity is also needed on aligning with labeling requirements in other states, and there must be a clear process and a timeline for labeling waiver applications.
Please wrap up.
SPAN has provided the Environment Department with specific language recommendations and will provide the Environmental Improvement Board with these language recommendations after the hearing. Thank you very much for your time today.
Thank you very much, Mr. Bemis. Scott Scanlon. Would you state and spell your first and last name?
Yes, ma'am. Scott Scanlon, SCOTT, Scanlon, SCANLAND.
Do you swear or affirm to tell the truth?
I do.
Thank you very much. I'll start your time.
Thank you. Good morning. Good afternoon, Madam Chair, members of the board, and Madam Hearing Officer. My name is Scott Scanlon on behalf of the Cookware Sustainability Alliance. Thank you for the opportunity to speak today regarding the implementation of House Bill 212, the PFAS Protection Act. As you know, there are approximately 15,000 PFAS chemicals, but fluoropolymers, the material used to coat nonstick cookware, the sector that I represent, are distinctly different. Extensive independent peer-reviewed scientific studies have proven that fluoropolymers are non-toxic and do not bioaccumulate in the body. They are orders of magnitude larger and heavier than other PFAS molecules, so they pass directly through the human system without absorption. Fluoropolymers are inert. They cannot attach to organic matter, are not water soluble, and pose no realistic risk of contaminating drinking water. These facts are well established in multiple refereed scientific journal articles. The U.S. Food and Drug Administration, under the Biden administration, has specifically authorized fluoropolymer-coated cookware as safe for food preparation. The FDA made the same findings, similar findings, going back to 1962 and again in 1982. Even more compelling, these same fluoropolymers have safely coated pacemakers implanted in human bodies for decades, underscoring their biocompatibility and lack of danger. House Bill 212 wisely recognizes this distinction by exempting products containing fluoropolymers with a per- or polyfluorinated carbon-only backbone or perfluorinated polyether backbone that are solid at standard temperature and pressure. This clear exemption covers nonstick cookware, exempting it from the Act's prohibitions and any subsequent regulatory actions, including PFAS reporting requirements. We believe fluoropolymer-coated Cookware fully qualifies for complete exemption under HB 212 under this language, and therefore should not be subject to additional labeling mandates. Imposing labels on these proven safe products would create unnecessary consumer confusion and undermine confidence in trusted kitchen essentials with no corresponding health or environmental benefit. We've also seen ideas floated that cookware should contain permanent labels embossed directly onto a pot or a pan. This would be unreasonably expensive, is not required in any other jurisdiction, whether in this country or any other nation, and takes the notion of labeling to new, completely unnecessary heights.
Would you wrap up, please?
Again, all for a product that's exempt under 212. I also note that a legislative memorial is merely a suggestion with no force of law. We respectfully request confirmation that these products remain exempt without labeling obligations, allowing New Mexicans to continue using these safe products. Thank you, ma'am.
Thank you, Mr. Scanlon. Is Allie Peck with us? Hello. Would you spell your first and last name, please?
Yeah, it's Allie, A-L-L-Y. Last name is Peck, P-E-C-K.
Do you swear or affirm to tell the truth?
Yes.
I'll start your time.
Okay, great. Thank you. My name is Allie Peck, and I am the Director of Environmental Policy and Sustainability at the Consumer Technology Association.
You're going to have to slow down.
Slow down.
I will try.
My name is Allie Peck.
I am the Director of Environmental Policy and Sustainability at the Consumer Technology Association. CTA is North America's largest technology trade association. The proposed rule implementing HB 212 will have a significant impact on manufacturers of electronics. PFAS is a broad class of thousands of chemicals necessary for the manufacture and function of electronics. There are not substitutions for these chemicals. They keep our products durable, water resistant, and from spontaneous combustion. While the industry is exploring ways to phase these chemicals out, experts estimate it will take years to identify possible replacements, and the European Chemicals Agency has agreed. Our primary concern is with the labeling requirements, both the timeframe and the overall necessity. The statute does not require labeling of products. It says the department may implement them to carry out the provisions of HB 212. The legislative intent was not to apply a broad labeling requirement immediately to all products, regardless of exemption. Thus, we believe the 2027 labeling mandate is clearly regulatory overreach and should be postponed. We manufacture for a global marketplace. EU, Asia, North America, all at once. It is impossible for us to implement new labeling with only a 6-month lead time. We need at least 2 years to make labeling changes. We expect to have CUU exemptions and do not believe that our products need to be labeled at this time, given no additional scientific evidence that supports it. So moreover, now is not the time to force us erroneous and frankly impossible labeling requirements on our products. Additionally, we ask that rules be enforced based on the date of manufacture. The rules right now propose enforcement based on the date of sale. It's impossible for our manufacturers to control or even know the date a product is sold to a consumer. We sell products in bulk to distributors and retailers. Products can sit on shelves for months. If date of sold is not changed to date of manufacturer, hundreds of products could be pulled from the shelves, and New Mexicans will not have availability to our products and may need to travel to neighboring states to buy them. This change that we are requesting would also align with Prop 65 in California and the Washington State Safer Product Rules. When it comes to reporting, we ask that the rules align wherever possible with reporting requirements in other jurisdictions. And then on de minimis, most chemical regulations around the world recognize the need for de minimis thresholds to avoid unnecessary reporting of byproducts and impurities. We ask that the rules include this. We have several other concerns around the CUU process, waivers, and other details that we have outlined in our written comments. We support the intent of the PFAS Protection Act. We want to keep consumers healthy and safe, but we are concerned that the implementation outlined so far would create serious issues for our industry. Thank you for the opportunity. I'm happy to take questions if needed.
Thank you very much, Ms. Peck.
Thank you.
Marquis Howland? Could you state and spell your first and last name?
Sure. Good afternoon, members of the Environmental Department, Improvement Board, and Hearing Officer. My name is Marquis Howland, and it's Marqui, and last name Howland, Howland.
Do you swear or affirm to tell the truth?
I do.
Thank you. I'll start your time.
I'm speaking in my personal capacity as both a concerned citizen and on behalf of the El Valle de la Cieneguilla Land Grant Association. I'm providing this comment today in strong support of the PFAS Protection Act. I urge the board to adopt the environmental rule as proposed. Recently, the Environmental Department installed a PFAS well filter at my home because these toxic chemicals are in my groundwater, as well as my neighbors. This is my second filter because of the basic need of clean drinking water. No one should be scared of their own tap water or have access to clean water, especially when we have generations of living in the area. Some of us have built our homes. Homes have been passed on from generation to generation. These forever chemicals show up in groundwater tests and continue to. Consumer products containing PFAS can harm our health as well as our property values, most importantly, our health. I have personal experience with the importance of this matter, as I've witnessed many of my neighbors suffer and or have passed away due to the effects from PFAS contaminated groundwater as well as PFOA, including myself and my family. I appreciate this opportunity to speak with you and share our concerns. I strongly urge our governor, the legislature, and the environmental department to adopt this act. With gratitude, thank you.
Thank you, Ms. Howland. Maxine Sandoval? If you would please spell your first and last name.
Maxine Sandoval, MaxineSandoval.
Do you swear or affirm to tell the truth?
I do.
Thank you. I'll start your time.
I am going to read a statement from my neighbor who couldn't be here today due to illness because of the contamination that we've been facing in our village for quite some years now. I want to express my concern with how the state is addressing PFAS in consumer products. Last year, HB 212 passed the legislation and was signed into law. The bill would eliminate PFAS from several consumer products as well as give the authority for NMED to adopt rules to allow for labeling of consumer products containing PFAS. While the law was well-intentioned, the exemptions given the law make the law inconsistent with laws that have passed in other states and only provide a fraction of the protection to New Mexico residents as offered in other states. HB 212 exempted some of the most widely used PFAS called fluoropolymers or PFAS plastics. Excluding fluoropolymers is inconsistent with the laws that regulate PFAS in products in 24 states and resulting in weaker protections for the health of New Mexicans. It is notable that other states, when faced with similar pressure from the chemical lobby, rejected these efforts, and I am disappointed that our legislature and this administration caved to pressure from the chemical lobby rather than working with the communities and the other states to ensure consistency. The saving grace of HB 212 is that the law gives the authority in the department to require labeling of products containing PFAS. The authority does not exempt fluoropolymers or other products that are exempted from the provisions requiring eliminating PFAS from products, yet the hearing and fact sheets issued by the department seem to indicate that the department will again unnecessarily limit the protections to New Mexico residents. The exemptions under consideration by the department include any product containing fluoropolymers, which includes a wide range of products, including cookware, textiles, cars, semiconductors, HVAC systems, and any internal component as accessible to consumers during the normal use of a product. These unnecessary exemptions demonstrate the department's unwillingness to grapple with the fact that PFAS infects our environment and our lives at every stage, from production to use to disposal. It is important for the department to understand the threat posed by PFAS, including fluoropolymers. Claims that fluoropolymers are safe or that they do not impact public health ignore the mounting scientific evidence of the harmful effects they can have throughout the entire life cycle. PFAS and PFAS plastics also contribute to the climate crisis. When fluoropolymers are made, they release many harmful chemicals into the air and water. The factories that make fluoropolymers have caused PFAS pollution in nearby communities and drinking water. This has happened in places like West Virginia and North Carolina and is well documented. In fact, many lawsuits and media stories about PFAS pollution are linked to the production of fluoropolymers like PTFE, which is used in nonstick cookware. In fact, it is estimated that 80% of the PFOA and PFOA-like PFAS that have been released to the environment is from fluoropolymer manufacture and use.
Ms. Sandoval, please wrap up.
We have also heard from industry that certain PFAS are necessary for the clean energy transition. This couldn't be further from the truth. PFAS do not solve the climate crisis. They contribute to it. Thank you for your time.
Thank you. Melissa Garcia? All right. Is there anyone else in the room who would like to offer public comment during this session? Come on up one at a time.
It's on the list.
Oh,
But
well, okay.
all right.
Give me your first and last name.
Kyle Thompson, spelled KYLE-THOMPSON.
Do you swear or affirm to tell the truth?
I do.
I'll start your time.
Thank you, Madam Hearing Officer. Hi, members of the board. Thank you for this opportunity. I'm here on behalf of Plumbing Manufacturers International, representing manufacturers that supply the vast majority of plumbing fixture and fitting products that are used across New Mexico and the United States. We have submitted detailed written comments, but today I'd like to focus on one item in particular, that being the labeling requirement for PFAS. To summarize our reasons for concern on this, number one, a broad PFAS label raises serious First Amendment concerns, which has been expressed. Number two, a mandated label that implies a hazard, even where the use of the product is safe and compliant, will increase the liability exposure of our members of manufacturers. And third, a New Mexico state-specific PFAS label is not practically workable in modern interstate commerce. Manufacturers today don't sell one unit at a time into individual states. Products move through national distribution. A manufacturer sells to a national retailer or wholesaler, which then routes inventory through regional warehouses to stores, contractors, and online fulfillment centers based on the demand of that area. The manufacturer is not asked, and often not even informed, where each unit ultimately ends up. And inventory is constantly rebalanced across the regions. So when one state creates some unique labeling requirement, it doesn't operate as a label only what's sold in New Mexico requirement. In practice, it becomes a label everything for nationwide distribution. We've seen this dynamic before. Many products sold nationwide carry a California Prop 65 warning, not because every unit was intended for sale in California, but because overlabeling becomes the only practical way for manufacturers to avoid downstream compliance risks. A New Mexico specific PFAS label would create the same outcome. This doesn't just burden manufacturers, it makes labels less meaningful to consumers because everything ends up carrying warnings for everywhere. New Mexicans deserve rules that work in the real world and deliver real PFAS reductions. The cost of maintaining a patchwork of labeling requirements would come at the expense of work that actually matters. Substitution, reformulation, and compliance with enforceable PFAS reduction limits. So PMI's request is simple. Please do not exercise your discretionary authority to adopt PFAS labeling requirements in the final rule. Focus instead on measures that can be implemented and enforced effectively. Clear product restrictions and reporting, so New Mexico achieves real measurable progress. Thank you, and I'm happy to answer any questions.
Thank you, Mr. Thompson. Let's see who else is in the room. I saw another hand. I realized I was handed two lists.
Hi, good afternoon.
Good afternoon.
It's Willis Reed, WILLISREID.
Do you swear or affirm to tell the truth?
I do.
I'll start your time.
Good afternoon, Madam Hearing Officer and members of the board. My name is Willis Reed, as stated, Senior Manager of State and Local Government Affairs with the Consumer Healthcare Products Association, which represents manufacturers of over-the-counter medicines, dietary supplements, and over-the-counter medical devices. We are appreciative of the substantial effort undertaken by the Environment Department in implementing the PFAS Protection Act, and we support the legislature's goal of protecting New Mexico residents from unnecessary PFAS exposure. We also would like to acknowledge and thank the department for its recent changes in its revised proposed rule, clarifying labeling exemptions for drugs, medical devices, and their packaging. We did submit written comments with additional detail, though I will briefly highlight the primary issues that we believe remain unresolved. First, the rule contains a clear contradiction regarding medical devices. Dental floss and feminine hygiene products are listed as covered products, subject to PFAS prohibition and testing requirements, though they are simultaneously exempted as FDA-regulated medical devices. Second, the rule does not provide workable clarity regarding the definition of the term intentionally added PFAS or the scope of product components. The term expected, as introduced in House Bill 212, introduces the uncertainty. Although the rule introduces a 100 part per million rebuttable presumption in the testing section, that standard does not appear to be applied consistently across all provisions, and without a clear and uniform de minimis threshold serving as a bright line, manufacturers cannot determine obligations with confidence. Finally, we believe the labeling compliance timeline for cover products is unworkable in its current form. If adopted, requiring new labels beginning January 1st, 2027 will leave less than a year to review full product portfolios, evaluate supply chains, and the like. We respectfully urge the extension of the labeling implementation to January 2028 and to include a defined sell-through period for products already in the supply chain or on retail shelves. In closing, we urge careful consideration of these complications before adopting the rule as drafted. Addressing these concerns now will strengthen implementation and clarify compliance and certainty. And I thank you all for the opportunity to comment. Happy to answer any questions.
Thank you, Mr. Reed. Is there anyone else in the room like to offer comment during this session? Our next session will be at 1 p.m. tomorrow. All right, I'm going to turn to the online commenters. We'll begin with Riaz Zaman, and please correct my pronunciation.
Good afternoon. No, that was fine. Riaz Zaman.
Zaman, thank you.
Yeah.
If you would spell that, please.
Riazzaman.
Do you swear or affirm to tell the truth?
Yes, I do.
All right, I'll start your time.
Good afternoon, Madam Chair, Madam Hearing Officer, and members of the board. Thank you for the opportunity to speak with you today. My name is Riaz Zaman, and I'm with the American Coatings Association. Our association represents 90% of the U.S. paint and coatings industry, including manufacturers of paint, coatings, sealants, and adhesives, and the raw materials that go into formulation. I will be talking today about the proposed labeling requirement, particularly noting the redundancy with federal labeling requirements and how the proposed PFAS labeling requirement can be misleading. I also raise several additional issues in my written comments that you will be receiving. Regarding the labeling requirement, consumers and downstream users already receive information regarding hazardous PFAS in many products. 2 federal laws require labeling for hazardous chemicals. One deals with consumer products, and the other law is for industrial and commercial products. In the paint and coatings industry, we often comply with both sets of requirements since products can go into multiple markets. It's also common to include information in English and Spanish. These laws require labeling and identification of carcinogens, reproductive toxins, and other health hazards. An additional statement noting that the product contains PFAS is misleading in that it gives the impression that any fluorinated chemistry or PFAS as used in the product is associated with contamination or health effects, and that's simply not the case. In many cases, the inference of a health hazard is contradictory to federal law when the PFAS component is not hazardous or it does not pose a significant hazard. One relevant use in the coatings industry is fluoropolymers used to make high-performance coatings. These are used in a variety of socially beneficial applications such as bridges and infrastructure, flame-retardant coatings used on industrial buildings to slow the spread of fire, water delivery systems, etc. Fluoropolymers are technically a PFAS, but they are non-toxic and non-bioaccumulative, so these are not contaminating waterways. Labeling such products as containing PFAS gives the false impression that these products have the same degree of health hazard as long-chain PFAS monomers such as PFOA and PFOS. Courts, when reviewing labeling under California's Prop 65, have held that labels improperly compel commercial speech in violation of the First Amendment when there is no scientific basis regarding health hazard. I provide additional details in my written comment that I will be submitting. I appreciate your consideration of those written comments, and thank you again for hearing my testimony.
Thank you very much, Mr. Zaman. We'll turn now to Bill Ernie.
Yes.
There you
Hi.
are. Hello.
Can you hear me?
If you would spell your first and last name, please.
Sure. First and last name, William Ernie, William Erny.
Do you swear or affirm to tell the truth?
I do.
Thank you. I'll start your time.
Great. Thank you. I am a senior manager of regulatory affairs for the RV Industry Association. RVIA is a national association representing RV manufacturers and aftermarket suppliers who build more than 98% of all RVs produced right here in the United States. RVing is about connecting people and families to the great outdoors. While classified as motor vehicles, consumers use RVs for camping and recreation, not as their primary mode of transportation. In fact, a typical RV is used for about 30 days during the year. A safe and healthy environment is a core principle for our industry, and we share your goal of removing harmful chemicals from products sold in New Mexico. In enacting HB 212, the legislature appreciated the importance of a science and risk-based approach to PFAS management, which we strongly support. As a result, many low-risk products, including motor vehicles and RVs, are exempt from most of the rules requirements, including reporting. This fact is prominently displayed on the NMED website, stating, quote, "The legislation includes important exemptions and enforcement provisions, such as medical devices and electronics, where PFAS is essential and does not pose serious harm to those using the products," end quote. However, in the proposed rule, the New Mexico Environmental Department made the determination to include exempted products under the labeling requirements. RVs are complex products comprised of thousands of individual parts and components, which are sourced across a diverse and global supply chain. And as a complex durable good, RVs are subject to an enormous burden under this rule's labeling requirements, a burden that is just as onerous as the reporting requirements, which we are explicitly exempt. Under the rule's labeling provisions, RV manufacturers would have to collect PFAS information on hundreds of parts and components and list them in an owner's manual, including their proximate location in the RV. The vast majority of items that contain PFAS are in internal systems, under the hood items, such as seals and gaskets, hoses, and electronics. And in most cases, PFAS is essential for the safety and environmental performance. Under normal use, consumers do not encounter internal components, and the legislature itself determined they pose no serious harm to consumers. So in summary, I would just like to say that requiring labeling for RVs is unnecessary, overly burdensome to RV manufacturers, and will cause confusion to consumers. As a result, we recommend that RVs be excluded from the labeling provisions as outlined in section 20.13.2.13. Thank you for this opportunity to provide input on this important rulemaking, and please refer to our comprehensive set of comments, which will be filed here later for your further review. Thank you.
Thank you, Mr. Ernie. Is Tate Mitchell on the platform? Abby Linsk. Darby Gottlieb.
Hi, yes, I'm here. Can you hear me okay?
Yes, thank you. Would you spell your first and last name, please?
Yes, Darby Gottlieb, DARBIGOTTLIEB.
Do you swear or affirm to tell the truth?
Yes, I do.
Thank you. I'll start your time.
Great. Thank you. Good afternoon, members of the Environmental Improvement Board. My name is Darby Gottlieb, and I'm the Senior Director of State and Regional Affairs at AdvaMed, the MedTech Association.
I'm sorry, ma'am. My name is Darby Gottlieb, and slow down.
I'm the Senior Director of State and Regional Affairs at AdvaMed. We are the largest medical technology association representing leading innovators and manufacturers transforming healthcare through earlier disease detection, less invasive procedures, and more effective treatments. Our over 600 members range from emerging companies to large multinationals and include device, diagnostic, medical imaging, and digital health technology companies. First, I want to thank Secretary Kenny and his staff in the Environment Department for their willingness to meet on the proposed rule and hear our concerns regarding the initial draft rule that was published late last year. The initial draft would have required manufacturers to place a state-mandated safety warning label on medical devices whose risks have already been rigorously evaluated by the FDA for safety and effectiveness. We appreciate the work of staff to update the rule before you today to extend some of those patient protections provided in the underlying bill to the labeling requirements of the rule, including for FDA-regulated medical devices. So today, I just want to reiterate the importance and our support for this exemption for FDA-regulated medical devices. Over the last 30 years, advancements in medical device technology have transformed treatment pathways. Minimally invasive procedures like leading cardiac surgeries rely on flexible fluoropolymer-coated guide wires to navigate the body safely and effectively. And so these materials have enabled life-saving procedures, increased patient access, and improved patient outcomes. So we sincerely appreciate your time and the department's work on this issue. And thank you, and I'm happy to take any questions.
Thank you very much, Ms. Gottlieb. Let's see, Dan Moyer. Is Dan Moyer on the platform? Nicole Colantonio? I think I see you there.
Good afternoon. Yes.
Would you spell your first and
Nicole,
last name?
Mhm. Nicole, Nicole, Colantonio, Colantonio.
Do you swear or affirm to tell the truth?
Yes, I do.
All right, I think you might want to mute your computer there. David, if I stop talking and she begins talking, are you going to be okay?
Yes, Judge.
Thank you.
Yes, Judge.
I'll start your time.
Thank you. Good afternoon. My name is Nicole Colantonio for the Air Conditioning, Heating, and Refrigeration Institute, AHRI. We represent more than 330 manufacturers of air conditioning, heating, refrigeration, and water heating equipment. Also represents more than 90% of all space and water heating equipment manufacturers in the U.S., all significantly impacted by the PFAS in consumer products proposed rulemaking. We urge the Environmental Improvement Board to adopt the proposed rule until our concerns are addressed. Specifically detailed in AHRI's comments, which we submitted on February 20th, are concerns regarding the labeling provisions. The legislator recognized that PFAS in certain applications are critical and not currently replaceable, that they do not pose a potential risk in certain applications, and that they are adequately regulated under other laws. AHRI urges the board to forego labeling requirements for HVACR and water heating equipment, which are already exempt from prohibition and reporting provisions. Labeling for HVACR and water heating equipment as provided in the proposed rule is unattainable. Under the proposed rule, labeling would require manufacturers to disclose every PFAS-containing component and the location of these components within the product. The level of detail regarding the component's location and chemical composition of the component could expose proprietary design details, and due to the high level of complexity in the supply chain, it's extremely difficult for manufacturers to ascertain which components contain PFAS, and even more difficult to identify which PFAS are present. AHRI supports efforts to mitigate PFAS in consumer products, but again urges the board not to approve the proposed PFAS in consumer products rule until these issues have been addressed. So thank you for your time today and allowing for me to testify. Again, our full comments and all of the detail has been previously submitted to the docket on February 20th. Thank you.
Thank you, Ms. Colantonio. Is Zach Valdez on the platform? Jean Harrington. All right, there will be several other opportunities for public comment, 1 o'clock each day. Anyone else at all before we return to the technical case? Oh, all right, thank you. Let's return then. Dr. Chapman, would you rejoin us up here? When we broke for lunch, Dr. Chapman had been examined by Mr. Trujillo. I believe we would move to Ms. Feebig at this point.
Thank you, Madam Hearing Officer.
And just to clarify for folks, if a witness gives only direct testimony, cross-exam can last for 30 minutes. If they give direct and rebuttal, their cross-exam can last 45. But go ahead, Ms. Febeck.
Thank you. Good afternoon, Dr. Chapman. Dr. Chapman, your formal training is in environmental life science, is that correct?
Yes.
But for the last several months, you've been working at the NMED as the Chief Science Coordinator for the Office of Strategic Initiatives.
Yes.
And in your role, you're called on to provide technical assistance on science, education, policy, and science communication, right?
Yes.
And you are the technical coordinator for the proposed rule,
Yes.
but you are not involved in the promulgation of HB 212, right?
No.
So any statements in your testimony, your written testimony regarding legislative intent are not based on your personal knowledge. Is that fair?
Yes.
Would it be fair to say that your expertise in this area is based on both your formal education and your experience working in strategic initiatives?
Yes.
And in that capacity, you reviewed and analyzed the scientific literature available regarding PFAS, right?
Yeah.
You have not published any literature yourself on PFAS, is that right?
I have not.
In your written testimony on page 6, you state that bioaccumulative, persistent, and toxic nature of many PFAS was a catalyst for passing the law, right?
Yes.
Is it fair to say that the purpose of the law then is to limit the existence of PFAS that have those PBT properties?
No.
Do any of the products that will be banned under the proposed rule contain PFAS that is not PBT?
Can you repeat that?
I said, do any of the products that will be banned under the proposed rule contain PFAS that is not PBT?
Yes, that's correct.
Okay. Another catalyst that you identified in your statement or in your testimony was to avoid making existing contamination issues worse. Is that right?
Can you repeat the question?
I said another catalyst for the rule that you identified in your written testimony was to avoid making existing contamination issues worse. Is that right?
Yes, I suppose I was speaking to broader contamination experience throughout the state.
And in your written testimony, you cite to military bases in New Mexico as a significant source of PFAS contamination in the state, right?
That includes Holloman Lake as well.
And that is largely owing to the use of aqueous firefighting foams on those bases.
Yes.
And there's peer-reviewed literature confirming that association, right?
Yes.
And documenting the extent of the contamination.
In various levels of the ecosystem in plants and animals, and also water concentrations as well.
Right. And you cite to that literature in your testimony, right?
I do.
And in your written testimony, you also state that consumer products are, quote, another major source of PFAS entering the environment, right?
That is true.
But you don't cite anything for that conclusion in your testimony, do you?
I don't believe that's the case.
Could you point me to the literature that you rely on to support that contention? It's on page 7 of your written testimony.
Earlier this morning, I spoke to a study about cosmetic emissions in Europe, and I mentioned other studies. I think it's that it's a 2023 article that I pulled that figure from in my summary today.
Okay. A 2023 article on what type of products?
Consumer products.
And when you're using the term consumer products, are you speaking of any particular subset, or is that the sort of panoply of consumer products writ large?
As indicated by my testimony that I provided this morning, that spans a wide variety of different consumer products. Some of those are cosmetics, paints, stuff like that.
Okay, and you do not attempt to quantify the impact that's attributable specifically to consumer products, do you?
I disagree.
Could you specify where you quantify the impact that is attributable to consumer products of PFAS contamination in New Mexico?
I am speaking broadly about that study about cosmetics in Europe with respect to their relative contributions to contamination, and testimony with respect to New Mexico specific effects of PFAS will be subject of another expert.
Okay, because just to reorient, I was asking you about the catalyst for the regulation, which was to avoid making existing contamination issues worse, right?
Yes,
And so presumably, as a New Mexico regulatory body, you'd be focused on existing contamination issues in New Mexico, right?
again, part of the goal here is to turn off the PFAS spigot in the state. It is extremely difficult to remediate diffuse pollution throughout the environment. And so one of the strategies is to turn off the spigot through consumer products.
Okay. Let's talk a little bit about the labeling provision. The EIB is not required to impose any labeling requirement by statute, is it?
Objection. Calls for a legal conclusion.
Ms. Feebig?
I think it's a fair question. He's put in substantial testimony in his written testimony about the rulemaking process, and his understanding is relevant to the proceedings.
So Dr. Chapman, if you can answer the question as a member of management for a regulatory agency rather than as a lawyer, go ahead.
It is my understanding that the EIB is authorized to adopt rules for labeling of consumer products.
Do you have an understanding as to whether they are required to impose labeling requirements?
It is not a requirement.
And the purpose of the labeling provisions in the proposed rule is to allow consumers to make informed choices about the products they bring into their home. Is that fair?
I would say that labels provide some clarity to consumers as to what is in their products.
And you stated in your written testimony that it's the department's view that labeling is a, quote, critical piece of the rule that will help restrict the flow of new PFAS from entering the state, right?
Yes.
And that would only be true if consumers decrease their use of products containing PFAS as a result of the label, right?
I think that the prohibitions are going to decrease the amount of consumer products in the state, regardless of label.
Right, but you said in your written testimony that the labeling is a critical piece because it will help restrict the flow of new PFAS from entering the state, right?
I think consumers can evaluate information on consumer packages and make choices from there.
What I'm asking you is, in order for your conclusion that labeling is a critical piece of the rule that will help restrict the flow of new PFAS from entering the state to be true, do consumers have to reduce their use of products containing PFAS in reaction to the label?
I think that's outside the scope of my testimony and will be provided by another witness.
Would you agree that the goal of the label is to dissuade consumers from purchasing products that contain PFAS?
I would ask you to refer to the testimony of Dr. Deb Dickerson.
Okay. I want to ask you a little bit now about figure 1 in your written testimony, which was on page 45 of your of exhibit 3. And in that figure, you give a detailed representation of the PFAS family.
Yes,
And you say much of the scientific literature is focused on PFAS, right?
I do.
Can you quantify what you mean by much?
As with the line of questioning this morning, that is difficult to do.
Okay. Would you say it's the majority of the literature?
I cannot say that.
I believe you testified this morning that there are about 14,000 different PFAS chemicals out in the world. Is that right?
The US EPA estimates that there are 14,000 PFAS chemicals.
Can you test for those individual chemicals? Is there a testing mechanism available for each of those chemicals?
Not to my understanding. Most current analytical methods are a subset of that.
Okay. Would you agree that it's difficult to study these individual compounds if you can't even identify them?
No.
Okay. You say in your written testimony that emerging literature suggests that fluoropolymers may not be as inert as initially suspected, right?
That is true.
So would you agree that there is a body of literature concluding that fluoropolymers are inert?
I spoke to the literature about how fluoropolymers are considered low concern, and I stated that many of those studies are authored by people that work for fluoropolymer producing companies, and those papers contain conflicts of interest statements.
And are you testifying that all the literature that concludes that fluoropolymers are inert was authored by industry representatives?
I don't have that information.
Okay. Is it your view that all such studies that conclude that fluoropolymers are inert should be disregarded due to conflict of interest?
No.
Could you speak to what proportion of those papers were authored by industry representatives?
No.
And you note the conflict of interest issue, but you don't necessarily discuss the conclusions in the studies. Do you disagree with the conclusions that the authors reached in those studies?
As I provided in my testimony this morning, the considerations that those studies think about are limited to very narrow subset. They don't consider life cycle emissions and the things that I discussed this morning.
Okay. In your written testimony, you give PTFE as an example of a fluoropolymer that is less inert than previously thought, right?
Can you clarify what you mean by that?
Yes. You reference in your written testimony PTFE having the ability to degrade at a cooking temperature.
I did.
Do you recall that?
Yes.
That's the only fluoropolymer that you specifically reference in your written testimony when you're speaking about emerging literature suggesting that the fluoropolymers are maybe less inert than previously suspected. I'm wondering if there are others in the literature that you've identified, or if it's really limited to the PTFE.
As I mentioned this morning, that is a particular example of direct consumer product use and exposure to PFAS. But again, the literature suggests that if you consider life cycle assessments of PTFE and fluoropolymer production, you're not getting the whole picture of the story.
How many fluoropolymers are there?
That's outside of the area of my expertise.
Okay. And are you aware that PTFE has been found to be safe by the FDA when it's used in medical devices?
I believe that Dr. Korzanowski cited the US FDA with respect to fluoropolymers in medical devices.
Is that a yes?
Yes.
Okay. I want to talk a little bit about PFAS in consumer products. On page 55 of your testimony, you discuss PFAS in consumer products. And you highlight various products specifically, including fertilizers, pesticides, food packaging, nonstick pans, textiles, and paints, right?
Yes, that is a site of a study from 2011 or 2020. Wow, 2021.
Okay. And none of those examples that you mention are complex durable goods, are they?
I would say that that list is non-comprehensive.
Okay. On the next page, you report that the highest concentrations of PFAS have been found in ski wax, leather, baking paper, and impregnating agents, right?
In one particular study that I cite in my testimony.
Okay. And those are again, not complex durable goods, right?
They are not.
And in figure 5, which I think is in that area, let's see, 55.
I believe it's page 56.
Okay, thanks.
Mhm.
In figure 5, that is a graphic of a number of different household products, right?
That is true.
And the only material that's listed in this graphic that might be a complex durable good is electronic products. Is that fair?
I believe this is outside of the scope of my expertise.
But this is your report, right?
This is not my report.
So you're just using this as an example of, is this just, why did you put this in your written testimony if it's not something that you feel competent to testify about?
I don't feel as though I can speak to what extent durable goods are represented there, or complex durable goods.
Okay, I understand. Well, the PFAS concentration for electronic products, as reflected in this table, is on the lower end of the products that are listed. Is that fair?
Yes, and the scale goes up to 5,000 parts per million. So being low on the scale doesn't necessarily mean that it's low in electronic products. In my testimony this morning, I spoke about car recycling and emissions of PFAS from a complex durable good in that particular instance.
Right. Actually, let's talk about that a little bit. So the proposed rule does not ban PFAS in motor vehicles in most instances, correct? It's limited to just certain applications. Is that right?
That's my understanding.
And the applications specifically are textiles and refrigerants, right?
I believe so.
And that's only if they're not preempted. Is that fair?
Yes.
Could you, and you discussed earlier that there was some literature suggesting that there were high concentrations of PFAS in I guess, the recycled components of a motor vehicle at the end of its life cycle. Is that what you were testifying about earlier?
Yes, and that spoke to the presence of PFAS in complex durable goods throughout the product.
Right. Can you quantify the extent of the PFAS found in those samples that was attributable to just textiles and refrigerants?
I don't believe that study did that.
Okay. I want to go back to the electronics for a moment. After the figure 5 in your report, in your written testimony, forgive me, I keep saying report. You talk a little bit about exposure pathways for different products, right?
I would like a specific passage that you're referring to.
Yeah, if we can go to page 58, in the middle paragraph, you talk about electronic products as a potential source of PFAS contamination as a consumer product.
This is for electronic waste disposal and pathways to exposure from there.
Right. And so my question was, when you discuss exposure pathways related to electronic products, you're focused on electronic waste disposal as the prime concern. Is that right?
It is a concern.
Is it your prime concern?
My perspective is that to fully understand all exposure pathways, one must consider both production, use, and disposal of a consumer product.
Okay, in your written testimony, you say the presence of PFAS in electronic products represents an avenue of human and environmental exposure through the generation and processing of e-waste, right?
I do.
But you don't identify these other areas of concern in your testimony, at least.
I don't know if that's the case.
Okay. I'm going to turn to your rebuttal testimony. So in your rebuttal testimony, you evaluated the submissions from Dr. Stanton and Ms. Maripes, right?
I did.
I'm sorry, you evaluated the emissions from,
Submissions. That you evaluated the submissions from Dr. Stanton and Ms. Maripes. And you criticized Dr. Stanton for stating in her testimony that PFAS as a class are not forever chemicals, right?
I believe in that passage, the way in which the testimony was written was meant to diminish or downplay the concerns about these substances.
The basis for the criticism that you put forth was that PFAS are subject to biotic and abiotic transformations, right?
As I testified to this morning, once released into the environment, PFAS can undergo various transformations.
Hi, I just had a question on, I want to file a APD protest, and I was wondering who to email it to.
I'm sorry.
Pam, where's that sound coming from?
Somebody is not muted who is speaking on the telephone. Ms. Feibig, this is a reporter. I would ask you to slow down just a little bit if you wouldn't mind.
Okay.
Thank you.
Have you taken care of the mute, Pam?
Yes.
All right, thank you. Please go ahead.
Well, all I wanted to clarify is that your criticism of Dr. Stanton saying that PFAS are not, as a class, forever chemicals is that you believe that the products are capable of degrading. Is that fair?
I would say that they are able to transform into the most persistent types of PFAS.
Which is essentially the same thing that she's saying by saying they are not all forever chemicals.
I believe in that context, it was to minimize the concerns over them.
Okay, so is it the issue that you don't really like her phrasing, but you're in agreement on the fundamental issue?
The carbon fluorine bond in organic chemistry is amongst the strongest. And so when the testimony is written in a way to downplay the persistence, again, it's a scale of persistent to most persistent, right? You have transformation, you have precursors, you have intermediaries, and then you have these terminal products. And so there was a conflation and a minimizing of the phrase in the popular press.
Okay. Talking about persistence, I understand it is your view that persistence is a common characteristic of all PFAS. Is that fair?
Yes,
But persistence alone is not necessarily a concerning trait, is it?
it is one piece of that puzzle. Yeah.
There are a lot of chemicals or items that are persistent in nature that are not necessarily concerning, right?
I would need an example to make an assessment on that.
Gold, for example, is very persistent, but it's not necessarily regarded as harmful. Is that fair?
I don't know about gold.
Okay. Would you agree that there are other characteristics that PFAS do not share as a class?
Can you clarify your question?
Yeah, so mobility, for example, is that a characteristic that all PFAS share, or is there variation among the different chemicals with respect to that characteristic?
I would say that mobility, there are a spectrum of speeds in which PFAS move in the environment.
Okay, so mobility is not a characteristic that all PFAS necessarily share.
I think we're maybe talking in relatives.
Okay, they're all not the same with respect to mobility. There's differences.
There are differences in mobility across PFAS.
And is that also true of bioaccumulative properties? Some are more bioaccumulative than others?
I would say so.
And is that also true of toxicity?
Yes.
And how are you defining persistence?
I don't know if I do in my testimony.
Well, you use the terminology, you use the word persistent. Is that a term that has a scientific meaning?
It has many.
And which one are you using?
This idea that once released into the environment, it's there for a long time.
Okay. Does that long time have to be a certain minimum threshold, 6 months, 10 years? Or is there a limit, a lower limit on what you would consider persistent?
I'm not sure.
Okay. Are there some PFAS that last longer in the environment than others?
Yes.
You also criticized Dr. Stanton for drawing conclusions about PFAS generally based on only one type of polymeric PFAS. Is that fair?
Are you referring to fluoropolymers?
Yes.
Yes, that's true.
Would you agree it's inappropriate to make conclusions about the entire class of chemicals based on a narrow subset?
Can you rephrase your question?
I said, you want me to repeat it or rephrase it?
Rephrase, please.
Do you believe it is appropriate to make conclusions about an entire class of chemicals based on a narrow subset of that class?
I don't believe that's the case.
I'm saying that you criticized Dr. Stanton for drawing conclusions about PFAS as a group of chemicals based on the narrow subset of fluoropolymers, right?
My point with Dr. Stanton's testimony was that it ignored that there are polymeric PFAS that do degrade in the environment.
Okay. Well, so your criticism is that it would be inappropriate to assume just because some polymeric PFAS do not degrade in the environment, that all polymeric PFAS do not degrade in the environment, right?
I think that's true.
So it can be concerning to draw a conclusion about a broader class of chemicals based on the behavior of a limited subset.
I'm not sure what you're specifically referring to.
Well, I'm referring to your criticism of Dr. Stanton's testimony and the basis for that criticism, which is that you found it problematic that she was making a generalization based on a limited subset of chemicals.
And are you saying that I did that somewhere?
No, I'm asking whether you agree that that is not a best practice.
My argument in my rebuttal testimony is that by focusing on only one type of polymeric PFAS, it ignores the fact that polymeric PFAS can transform into non-polymeric concerning PFAS.
Right. And the reason that that would be an inappropriate thing to do is because you can't generalize from one subset to the broader class because there could be differences between them.
I believe that testimony was narrow in scope with respect to polymeric PFAS.
Okay. You indicated in your rebuttal testimony that most of your criticisms of Dr. Stanton's testimony regarding the accuracy of the labeling have been superseded by modifications to the proposed rule, right?
I don't know if I would characterize it as most.
How would you characterize it? Would you say all?
No, yeah. Can you, repeat your question?
So I think in your rebuttal testimony, you specified that the proposed rule had been revised following Dr. Stanton's written testimony being submitted.
And I think that was referring to it being referred to as a warning label when it had environmental and human health effects.
Right. And you said, so on page 9 of Exhibit 71, you say the second half of Dr. Stanton's testimony focuses on the claims that the proposed regulations are not scientifically accurate. And you say her testimony was written and filed prior to the department filing the revised proposed rule, which incorporates considerable feedback. And you conclude at the end here with this eliminates the argument from Dr. Stanton's testimony that requiring all PFAS containing products to include a label suggesting they pose risks is inaccurate.
I believe I'm referring to the passage of Dr. Stanton's testimony where she quote says, requiring a label that communicates hazard for all PFAS is in the definition is overly broad.
Okay. Well, what I was really wanting to ask you about is whether you believe that the revisions to the proposed rule address the issues that Dr. Stanton had raised in her testimony.
It is my perspective that the Erlenmeyer flask with the word PFAS inside does not communicate hazard.
Okay. On page 12, there is one area of the labeling requirement that you mentioned in the rebuttal testimony that I wanted to question you about. On page 12 of that testimony, you say that the rule does not require vehicles to be labeled, only the owner's manual. Is that your understanding of the revised rules requirement?
That is my understanding.
Were you aware that subsection D1 of the proposed rule says a statement indicating the presence of intentionally added PFAS shall be included in the specification sheet and other product labeling information available to potential consumers prior to purchase?
I guess I was using those interchangeably. And the point was to speak to not individual components of the vehicle, just literature associated with the vehicle.
So
because she was speaking about a vehicle owner's manual. If it's a hot water heater, maybe that's a specification sheet. It's context specific.
well, the rule says that the proposed rule says that a statement has to be included in the specification sheet and any other product labeling information available to potential consumers. Are you saying your interpretation of it is different from that it's sort of a pick and choose, that manufacturers can decide where they want to place the Erlenmeyer flask?
My understanding in this particular instance of a vehicle is that it would occur in the owner's manual.
And not in the label?
Not in the label?
Yeah, you're saying that it would only, the regulation requires that it be included on a specification sheet and any product labeling information that's available to potential consumers. You're saying that a vehicle manufacturer would not have to comply with that provision. They could only put it in the operator's manual. Is that your understanding?
I guess in this particular instance, because we were speaking of the vehicle, I thought of owner's manuals, but I do suppose there are specification sheets associated with vehicles.
Okay. You're the technical, sorry, I don't want to mischaracterize it was the technical coordinator for the rule, is that right?
That works, yes.
Okay. And part of that job involved outreach. I think you described a substantial amount of outreach that you all undertook in the process of promulgating the rule, right?
Yes, we met with many interested parties.
Did you confer with manufacturers of, let's say, vehicles, for example, to understand what this provision that we've just been talking about might mean in practice?
I believe we had some meetings with vehicle manufacturers.
Did you collect information about what types of specification sheets or labels or manuals might sort of be out there in the world that would have to be revised in order to comply with this?
Not that I recall.
Okay, and then subsection D4 of the proposed regulation talks about manuals, right?
We're talking about labeling still.
Yeah, we're still talking about labeling and labeling of complex durable goods specifically.
Section D, yes.
Yeah. And it's not the section on operators on manuals is not limited to just adding the Erlenmeyer flask and the PFAS symbol to the operator's manual, is it?
Can you clarify your question?
So the subsection D4 of the proposed regulation, which discusses the operator's manual for complex durable goods, is not only requiring manufacturers to add the Erlenmeyer flask symbol to the manual. Is that right?
If you're asking if we are hoping that manufacturers supply a list of PFAS in components and their general locations, I don't know if that's what you're asking.
Yeah. So I believe in your rebuttal, you suggested that the only thing that a vehicle manufacturer would have to do is add an Erlenmeyer flask symbol to the operator's manual of the vehicle. And I want to probe your understanding of what the proposed regulation requires in that scenario.
I would like to quote my rebuttal testimony, if that's okay. I said, quote, first, the rebuttal rule does not require the vehicle to be labeled, only the owner's manual. I don't take that to mean that it doesn't list elements of components that contain PFAS in the vehicle, in the owner's manual.
Okay. Well, I think a minute ago, you just said you hope that manufacturers will provide a list of components that contain PFAS within the products, right?
Well, I hope that the EIB adopts the rebuttal rule that would require that.
Okay. But just to be clear, if the EIB does adopt the rebuttal rule, it would require that, right? This isn't an optional or, it's not a voluntary compliance provision. This is a requirement.
That is how the department has proposed that complex durable goods label their products in accordance with these proposed regulations.
And in addition to providing the list, they would have to give sufficient detail to locate the component within the product, right?
I believe that is the case.
And it would have to be done for the operation manual and for the maintenance manual, right?
I would have to think about that, I guess. I don't know if that is explicitly enumerated in the proposed rebuttal rule.
Okay. And whatever has to be done would have to be done in English, Spanish, and any other language that the manufacturer presently uses, right?
I believe that's the case.
Okay. I can just have one moment to look over my notes. I think I may be about
Yes.
finished. Okay. Thank you, Dr. Stanton.
No problem.
Chapman.
Thank you, Ms. Feebeck. We should take a 10-minute break or so before we turn to the next examiner. Let's come back at 2:35. All right, we are back after a short break. I wanted to mention that Board Member Curry joined us on the platform earlier. And we'll turn now to, let's see, Mr. Boutier, do you have questions of Dr. Chapman?
Madam Hearing Officer, thank you. No questions.
All right, Mr. Boutier said no questions. Mr. Weatherby, do you have questions?
No, Madam Hearing Officer, I don't have any questions at this time. Thank you.
All right, thank you. And I have Mr. Lopez monitoring whether Dr. Bennett joins us, but has not been seen on the platform. So is there any redirect?
Yes, Madam Hearing Officer, just a couple of questions.
Go ahead, Mr. Smith Karen. My memory was 10 minutes.
Okay.
That's my memory.
Dr. Chapman, earlier you were asked about the timeline with respect to NMED's review of CUU proposals. Do you remember that?
I do.
Isn't it true that 20.13.2.11a of the rebuttal rule provides that complete CUU proposals for sales prohibitions effective January 1, 2027, received by October 31, 2026, will be considered approved pending review, and a final determination of whether to approve or deny the proposals will be issued by the department by March 1, 2027?
That is true.
Thank you. And I believe that earlier you testified that the 19 technical citations that were published with the public notice in this matter served as the basis of the proposed new rule that NMED filed on October 8, 2025.
That is true.
Is that right?
Yes.
Okay, that's all I've got. Thank you, Madam Hearing Officer.
Thank you very much, Mr. Smith Karen. Dr. Chapman, you now get to answer questions asked by board members. Member Sweeney, would you like to kick off the questioning?
I actually don't have any questions at this point.
All right, thank you. Chair Ely?
Hi, good afternoon. I'm Dr. Chapman. Nice to meet you. Just a few questions. And if I'm assuming you're the appropriate person to answer these. If not, just please let me know and we can defer some of these questions till later. On the labeling requirement, new labels have to be in place by January of 2027. Is that correct?
Madam Hearing Officer, Chair Ely, yes, that is correct.
And what did you consider when establishing that date? I've heard industry arguments that there's just not enough time. What were your considerations when setting that date?
I don't know if I have that information, but I do know that we heard interested party concerns with timelines and revised the rule so that labels are required on consumer products manufactured after January 1st, not sold.
Thanks for that clarification. That's helpful. And then there are provisions in the rule for a waiver for the labeling requirements, correct?
This is true.
And will there be, how long do you think it would take to process a waiver, make a decision on a waiver? Would it be possible to have any potential waivers in place before the January 1st deadline?
I'm just reviewing rule here quickly. As contemplated, the rebuttal rule says that if label waiver requests are received by October 31st, 2026, they're considered approved pending review, and final determination will be given by June 1st, 2027.
Great, that's helpful too. You've referred to other state programs, other states that regulate PFAS, and listed a number of them: Connecticut, Vermont, Colorado, How many states in the US do regulate PFAS? Do you know?
It's hard to say. There's various levels of consumer product phase outs. Some states are focused on a narrower set of products. I would say that New Mexico's prohibitions and phase outs most closely mirror states like Minnesota and Maine.
And then on the labeling requirement, it sounds like we are unique in adding, or the proposed adding of a flask with PFAS inside that flask to denote intentionally added PFAS in the product.
The symbol would be unique. The words that are discretionary next to the flask are shared with Colorado and Connecticut.
So would products that go into Colorado be acceptable labeling for products that would come into New Mexico?
I believe there are provisions in the rebuttal rule to accept other states' labeling regimes, so long as it contains New Mexico specific information, and that can include updating websites, phone numbers, and stuff like that.
You made significant revisions between the two rules, the rebuttal rule and the previous rule in the labeling section, including removing language regarding the hazards of PFAS. So one of my questions is, how do you educate the public on the hazards of PFAS? I mean, they'll see the label and then they'll say, oh, well, what does this mean for me? What's the intention of the department to educate the public on those hazards?
As a part of the implementation of the PFAS Protection Act, the department is working on building out a public awareness campaign that includes various strategies to educate the public on various effects of PFAS.
I'm not real familiar, I worked for years in the department. I'm not real familiar with the Office of Strategic Initiatives. Could you describe the structure a little bit to me and who the lead of that program reports to?
I'll do my best. I'm relatively new as of August of 2025, but the office is led by Christina Keys in the audience, and Christina reports to Environment Secretary James Kenney.
And so will it be Christina Keys that leads the implementation of this rule?
Up until now, the implementation has been led by Christina Keys. There are provisions as we get closer to implementing that will be handled by the Compliance and Enforcement Division.
So I'm just wondering about, and maybe another witness is better able to answer this question, but the ability of staff to, move through the labeling requirements or, the consideration of products that are, UUC products, do you have the staffing that you need to fully implement the program?
I would refer to Secretary Kenney's testimony as well as testimony provided by Dr. Kyle Staggs.
Great, that's all. Thank you.
Thank you. Member Bitzer on the platform, do you have questions of Dr. Chapman?
Not at this time. Thank you.
All right, thank you. Member Carrasco, do you have questions of Dr. Chapman?
I do not.
All right, and Member Curry, do you have questions of Dr. Chapman? He may have stepped away. All right, thank you all. Thank you very much, Dr. Chapman. Oh, sorry. Board Counsel has a question of Dr. Chapman. Go ahead, Mr. Ugarte.
Thank you, Madam Hearing Officer. Excuse me, Dr. Chapman, I'm going to refer to Figure 1 in your direct testimony. It's on page 45. So I don't know, does your council have that available to share on the screen? If it's going to be too long. I went to law school for a reason, and I'm still trying to understand the whole PFAS thing. This is where you have the graphic that has the non-polymers and the polymers.
Yes, that's in my slides for today.
Okay. So I want to thank the department also for a really deep NOI. It was a lot to read. And one thing that I'm trying to figure out is PFOS and PFOA, where on here would they fall?
Those are considered PFCAs and PFSAs under the perfluoroalkyl acids. So they're below subgroup in PFCAs on the left side of that figure.
Okay.
And PFSAs.
All right. And those are the ones that I think the testimony described that those are being or have been phased out.
In the United States.
Correct.
But imported products can still contain them.
All right. But they fall under this, I guess, the bigger umbrella of PFAAs?
That's correct.
Okay. All right. I think that's it. Thank you.
All right, anything further from the board? All right, thank you very much, Dr. Chapman, for your testimony.
Thank you. Thank you all.
Madam Chair,
Oh,
if I may
sorry,
interrupt,
Mr. Trujillo.
unless I'm mistaken, I don't think the department has moved to admit the exhibits. The reason I raise it is because I have objections, so I want to not have to do that later.
Thank you so much. Mr. Smith here.
Yep, I move to admit all of Dr. Chapman's exhibit to the record.
All right, do I hear an objection to that?
You do, Madam Chair, and I'll make two objections, then I have a proposal and to not have to continue to do this for the rest of the hearing. But relative to this witness, based on Dr. Chapman's testimony, I would renew my objection to admitting exhibits not disclosed as part of the public notice as previously discussed. In addition, I would object to the admission of testimony that relied on such technical information not disclosed as part of the public notice. And then I'll discuss how to handle this maybe going forward after.
Sorry, your objections are noted and overruled. What's your proposal?
I'll do some research tonight, but I think to make sure that it's proper, but I think I would just like to make a continuing objection to the other witnesses. I'll double check to be able to preserve that issue. That would suffice. I think it will, but I'll double check I think we'll have probably one, maybe two more witnesses today.
All right, I think so too. We've definitely had that in other rulemaking hearings. But we can confirm that later. So thank you very much.
Absolutely. Thank you.
All right, thank you, Dr. Chapman. And Mr. Smith here, do I understand that we're going to Dr. Mitch Olson?
Yes, that's correct, Your Honor, and he will be presented by my co-counsel, Andrew Knight.
Oh, terrific. Dr. Olson, would you spell your first and last name, please? You need to turn on the microphone. There you are.
There we are. Thank you, Madam, excuse me, Madam Hearing Officer. My name is Mitchell Olson, MITCHELLOLSON. You can call me Mitch.
Thank you. And do you swear or affirm to tell the truth?
I do.
Thank you very much. And because you are a direct witness, everything is 30 minutes. Mr. Knight, go ahead.
Thank you. Mr. Olson, where are you employed?
At Colorado State University.
Excuse me, Dr. Olson. How long have you been employed there and what is your current position?
I've been employed there since May 2024. I am a research associate professor in the Department of Civil and Environmental Engineering.
And briefly describe your education and professional qualifications.
Very good. I have a bachelor's degree in chemical engineering from the University of Minnesota Duluth, master's and PhD degrees in environmental engineering from Colorado State University.
Would you please keep it slow?
Yes.
Thank you.
Thank you for the reminder. I'm a professional engineer with 25 years of experience, including over 10 years working with PFAS. My PFAS experience includes consulting, project support, and company program development, academic research, and contributing to professional organizations. As a consultant working for TriHydro, based in Laramie, Wyoming, excuse me, I served as Emerging Contaminants Director, overseeing development and
I'm
implementation.
sorry, sir. I served as
I served as Emerging Contaminants Director, overseeing development and implementation of the company's PFAS program. Last year, I transitioned from consulting to my current role as a research professor at CSU. My lab is conducting research on various aspects of PFAS, fate and transport, and treatment technologies.
I'm sorry, sir. My lab is conducting research
on various aspects of PFAS, fate and transport, and treatment technologies. And I've provided PFAS training to several thousand people through involvement as a lead trainer in the ITRC's PFAS team.
Thank you. Did you file a written testimony in this matter?
I did.
And do you have any corrections that you would like to make to that written testimony?
I do not.
Do you therefore adopt that written testimony as your testimony here today?
I do.
Great. Well, please provide us with a summary of your written testimony then.
The purpose of my testimony is to provide a high-level orientation on important PFAS chemistry concepts. PFAS is the acronym for per and polyfluoroalkyl substances, the chemical family that includes over 12,000 individual compounds. My testimony will focus on PFAS naming conventions, family tree, and select chemistry properties that contribute to the unique challenges of PFAS. Over the past 10 years, I've worked on addressing the PFAS challenge from multiple perspectives, including as a consultant, as a professor, and as a member of professional organizations. My consulting experience with PFAS comes through working for TriHydro, a Wyoming-based company of approximately 500 people. At TriHydro, I served as Emerging Contaminants Director, overseeing
sorry,
development.
sir. Excuse me. You are just going to have to slow down. My consulting experience with PFAS comes from working with
for TriHydro, a Wyoming-based company of approximately 500 people. At TriHydro, I served as Emerging Contaminants Director, overseeing development and implementation of the company's PFAS program. In May 2024, I left consulting to begin my current role as a research professor at CSU. My lab is conducting research on various aspects of PFAS, fate and transport, and treatment technologies. My research is funded by various sources, including federal government, state government, and industry. Oh, looks like we are one slide ahead, actually. Could you go back one, please? Perfect. Membership in professional organizations and active contributions to these organizations has been a very important part of my PFAS experience. I've been involved in ITRC's PFAS team since its inception in 2017. ITRC stands for Interstate Technology Regulatory Council, which is a nationwide organization that writes consensus-based guidance documents on a variety of environmental topics of concern and provides supporting training. I have contributed as an ITRC trainer on several online training events via the US EPA's online training platform, as well as live in-person events. Through ITRC, I have provided training on several PFAS-related topics, including chemistry, history and use, naming conventions, fate and transport, and biosolids applications. ITRC's online training events regularly draw several hundred live attendees and thousands more online streaming views. The information I am providing as a part of this testimony is entirely based on or aligned with ITRC's PFAS guidance document and training program. While I am using materials produced by ITRC, this testimony is not an official ITRC training course, and the content has not been reviewed or approved by ITRC. This testimony will include key background information on PFAS, starting with a summary of their history and use. PFAS are anthropogenic or man-made chemicals that were invented in the 1930s and have been widely produced and used since that time. Their water and oil repellent properties have led to their widespread use in non-stick and water or stain repellent coatings or fabrics. Their surfactant properties have led to use in mist suppression in various industries. Their surfactant properties, coupled with stability under extreme conditions, makes them very effective at extinguishing Class B fires associated with flammable liquids or fuels. Beyond these uses, PFAS and PFAS-containing products are used in many industries, including electronics, metal plating, leather production, paper, and others. The health concerns associated with PFAS were identified in occupational and internal industry studies by the 1970s. Environmental concerns around PFAS did not emerge until the late 1990s to early 2000s, when analytical methods improved to the point where low part per trillion concentrations could be detected in environmental samples. The realization of PFAS presence in groundwater at low part per trillion concentrations has ushered in the current era of evolving PFAS regulations. The large number of commercial and consumer product uses for PFAS led to varied potential sources of the PFAS that have made their way into the environment. Potential PFAS release pathways may include atmospheric discharge, direct water runoff, wastewater discharge, solid waste disposal, firefighting foam deployment for training or incident response, and other pathways. Until recently, PFAS were not considered to be hazardous substances and have historically been released, discharged, or otherwise disposed with little regulatory or permit limitations. Furthermore, wastewater plants or landfills are not considered to be large-scale direct users of PFAS, but wastewater plants or landfills may serve as concentration points for PFAS due to their presence in wastewater received by treatment plants or solid waste received by landfills. Upon release into the environment, PFAS may migrate through groundwater, surface water, or in the atmosphere, as covered in the testimony of Eric Chapman. PFAS is an umbrella term for a family of chemicals that includes over 12,000 individual chemicals. Of those thousands of chemicals, a relatively small number are included in conventional analytical methods, and an even smaller number are subject to current regulations. ITRC developed a diagram referred to as the PFAS family tree to help with organizing PFAS chemicals based on chemical structures. A link or QR code to this figure in the ITRC document is provided here. The PFAS family tree includes multiple divisions and subdivisions, a few of which are of key importance for understanding the current state of science and regulation for PFAS. At the highest level, this includes polymer and non-polymer PFAS. The non-polymer PFAS are generally considered to be more mobile in the environment. An important subgroup within the non-polymer class is the perfluoroalkyl acids, or PFAS, which include many of the most widely studied and regulated PFAS. Within the non-polymer PFAS, there is another important distinction, that of per and polyfluoroalkyl substances. Perfluoroalkyl substances are not considered to be susceptible to degradation under normal environmental conditions. Conversely, the polyfluoroalkyl substances are partially susceptible to reaction.
Sorry, sir, can you start that statement again?
Conversely, the polyfluoroalkyl substances are partially susceptible to reaction and are sometimes referred to as PFAA precursors or just precursors due to their potential to transform into PFAAs. All of these distinctions, polymer versus non-polymer, per versus polyfluoroalkyl substances, as well as the PFAAs, will be discussed in more detail later in this testimony. The reason PFAS are so widely used in consumer products and industrial applications is the unique chemistry of PFAS, which provides functions that are valued in modern society. However, many of the properties that make PFAS desirable in certain industries or consumer products make them challenging to manage at the end of their useful life. The purpose of this section is to provide an overview of the chemical properties that differentiate PFAS. Perfluorooctanoic acid, spelled on this slide, better known as PFOA, is one of the thousands of PFAS chemicals. For the purpose of this testimony, we will focus on PFOA as a model compound for an overview of some of the important chemical features that apply to most chemicals in the PFAS family. A common feature of the PFAS family is the head and the tail. The tail consists of a carbon backbone that is saturated with fluorine. The tail is hydrophobic and oleophobic, meaning that it repels both oil and water, which gives PFAS some of their properties that lead to widespread use, such as nonstick coatings, waterproof or stain-proof fabrics. The head is non-fluorinated and can include many chemical combinations of carbon and other elements. For many PFAS, The head is hydrophilic or attracted to water, which contributes to the high mobility in water for many PFAS. The combination of the hydrophobic tail and the hydrophilic head makes PFAS effective surfactants, leads to a tendency for PFAS to form foams and accumulate at air-water interfaces. Two more important features of the fluorinated tail of PFAS compounds are the carbon-fluorine bond and the chain length. The carbon-fluorine bond is among the strongest single bonds in organic chemistry, which contributes to the extremely high chemical stability for PFAS. The chain length refers to the number of carbon atoms in the fluorinated tail of PFAS compounds. I will talk about this in more detail, but the chain length is an important factor in PFAS mobility in the environment, treatability, and bioaccumulation. Finally, a note on the chemical definition for PFAS. PFAS are considered to include thousands of individual chemicals, but there is not a single definition for what constitutes a PFAS chemical. Even within the US EPA, definitions vary by statute and purpose and tend to rely more on identification of individual compounds by name rather than general chemical structure. Another commonly cited definition is advanced by the organization.
Start that again. Another commonly
cited definition is advanced by the Organization for Economic Cooperation and Development, or OECD. I will refer anyone who is interested in digging further into PFAS definitions to the ITRC guidance, Table 2.1, which summarizes PFAS definitions from various entities. However, for the purpose of the proposed rule, as noted, New Mexico has promulgated a definition of PFAS. Fluoroalkyl acids, or PFAAs, are an important subgroup in the PFAS family tree. The PFAAs are found in the non-polymer class and the perfluoroalkyl acid subclass in the PFAS family tree. The PFAAs are of high importance for three primary reasons. First, PFAAs are the focus of many state and federal regulations. Second, they are the majority of compounds included in conventional PFAS analytical methods. Third, they tend to be the drivers for remediation and water treatment where PFAS cleanup is implemented. In terms of the PFAS family tree, PFAAs are further divided into two subgroups. The perfluorocarboxylic acids, or PFCAs, include PFOA and related compounds of varying chain lengths. The perfluorooctane sulfonates, or PFSAs, include PFOS and related compounds. PFOA and PFOS are the two chemicals in the PFAS family with the longest production history and have been
Sorry, sir. Start that statement again, please.
PFOA and PFOS are the two chemicals in the PFAS family with the longest production history and have been the focus of the earliest waves of PFAS regulations. An important feature of the PFAAs is that they do not degrade to a meaningful extent under typical environmental conditions. However, PFAAs may be formed due to transformation of polyfluoroalkyl substances, which I will talk about further later in this testimony. Because the PFAAs are the focus of many existing state and federal regulations and are also included in most PFAS analytical methods, the established naming convention for PFAAs is important to understand and interpret PFAS methods and regulations. Briefly, the PFAA naming convention consists of 4 or 5 letters in the form PFXY, where PF stands for perfluorinated, X is a 1 or 2 letter acronym for the chain length, and Y is either A or S to indicate the head functional group. PFCAs end with A, and PFSAs are indicated by S. For example, the acronym for perfluorooctanoic acid is PFOA. PF for perfluorinated, O for octane, indicating an 8 carbon chain, and A for carboxylate. For other PFCAs with varying chain lengths, the O would be substituted with another letter from this table. The ITRC guidance document, Table 2-2, is a useful summary table of the PFAA chemical names and acronyms. Chain length refers to the number of carbons in the fluorinated backbone. Chain length is an important factor in mobility, treatment, and exposure. Long-chain PFAS are generally less mobile in the environment, simpler to remove from water streams via current best available treatment processes, and are considered to be more bioaccumulative. Conversely, short-chain PFAS are generally more mobile may be more difficult to remove from water and considered to be less bioaccumulative. PFCAs with chain lengths of 8 or more carbons are considered long chain, whereas PFSAs with 6 or more carbons are considered as long chain. The long chains, short chain division is different for PFCAs and PFSAs, primarily due to the transport and absorptive properties. PFSAs with 6 or more carbons behave similarly to PFCAs with 8 or more carbons. In addition to the long and short chain PFAS, ultra short chain PFAS are attracting increasing attention in publications.
I'm sorry, sir. I've lost you again. In addition to the long and short chain.
In addition to the long and short chain PFAS, ultra short chain PFAS are attracting increasing attention in publications. Ultra short chain PFAS comprise chains of 2 or 3 carbons. The ultra short chain PFAS are not subject to wide regulations at this time, and in general, information on their occurrence in the environment is limited. Precursors are another feature that differentiates PFAS from other contaminants of concern. Precursors are polyfluoroalkyl substances that may partially degrade or transform, but should not be expected to degrade completely under normal environmental conditions. In comparing the two classes of non-polymer PFAS in the family tree, per and polyfluoroalkyl substances both include tails comprising a carbon backbone that is saturated with fluorine. However, for polyfluoroalkyl substances, the head includes at least one carbon that is not fluorinated and therefore susceptible to transformation. The end products of polyfluoroalkyl substances transformation reactions are often PFAAs. Because of this, polyfluoroalkyl substances are often referred to as PFAA precursors, or just as precursors. Precursors are produced in many chemical forms. The head is non-fluorinated and can include many chemical combinations of carbon, hydrogen, nitrogen, and other elements. The non-fluorinated head may carry an ionic charge. PFAAs in water are anionic or negatively charged, while PFAA precursors are more complex and may be anionic. They may be cationic or positively charged, Zwitter ionic, which is both positively and negatively charged, or neutral. The charge plays an important role in mobility. The neutral or positively charged molecules are more likely to be retained on soils via electrostatic interaction. PFAS production processes have varied over time through different manufacturers and for different end uses. The chemical composition or fingerprint of a PFAS product can vary substantially depending on the production process and intended use. Products may consist of primarily PFAAs, primarily precursors, or some combination. Evaluating the PFAS fingerprints associated with the various manufacturers and times remains an area of active research with implications in terms of source identification or differentiation. As a final note on precursors, and to illustrate their relevance, it is not uncommon to see PFAA concentrations higher in wastewater treatment effluent than influent, due to the presence of precursors in the influent stream and transformation reactions during the wastewater treatment process. Complete degradation or mineralization of PFAS, including PFAAs, is only achievable under conditions engineered for elevated temperatures or enhanced energy input. Next, I will discuss the polymer and non-polymer PFAS classes. Polymers are large molecules constructed of smaller molecules, or monomers, that are chemically bonded together in a repeating pattern. Because of their relatively large molecular size, polymers are generally considered to be less mobile in the environment than non-polymer PFAS. For PFAS, polymers are divided into 3 subclasses: fluoropolymers, polymeric perfluoropolyethers, and side chain polymers. Fluoropolymers are commonly associated with plastics and rubbers used in chemical and or heat-resistant environments. Commercially produced fluoropolymers include polytetrafluoroethylene, or PTFE, polyvinylidene fluoride, PVDF, and fluoroelastomers. Polymeric perfluoropolyethers, or PFPEs, are different from fluoropolymers in that they are comprised of an alternating carbon-oxygen backbone with only the carbon being fluorinated. The PFPEs are generally less well studied than fluoropolymers, but are primarily associated with use as grease and lubricants. Side chain polymers are primarily associated with surface protection products. Side chain polymers include a non-fluorinated carbon backbone with fluorinated carbon branches extending from the backbone. Under certain conditions, PFAAs or PFAA precursors may break free of the polymer chains. Thus, side chain polymers can potentially function as PFAA precursors. A final category for consideration is that of PFAS replacement chemistry. As the impacts of PFAS in the environment have become better understood, chemical manufacturers have pursued alternative methods to meet the product or application needs, including fluorinated and non-fluorinated chemical alternatives. Replacement chemistry has taken many forms, including substitution of longer chain PFAS with shorter chain substances, or phasing out certain manufacturing processes or products. In the US, production of two PFAS compounds, PFOS and PFOA, was largely discontinued in the 2000s to 2010s. 3M was the sole PFOS manufacturer in the US, and 3M discontinued production of PFOS in the early 2000s. In addition, the US EPA initiated a PFOA stewardship program between 2005 and 2015, which eliminated most PFOA production in the US. That being said, international production may persist for some of these compounds that have been phased out in the US. Over time, formulations have changed and have tended towards short chain PFAAs and precursors. For example, conventional firefighting foam formulations have been referred to as C8 due to the fact that they were based on 8 carbon chain length compounds, such as PFOA, PFOS, and their associated precursors. More recently, foam formulations have migrated towards a C6 chemistry. Under normal conditions, the C6 compounds cannot transform into longer chain compounds. Thus, C6 precursors could transform into PFAAs of 6 carbon chain lengths or shorter. Another example of replacement chemistry is the production of HFPO-DA, which is an acronym for hexafluoropropylene oxide dimer acid, but also commonly referred to as Gen X chemicals. HFPO-DA was produced as a replacement for PFOA, but was subsequently included in federal drinking water regulations with an MCL, or maximum contaminant level, of 10 parts per trillion. To summarize key points, PFAS have been widely produced and used for decades due to their unique properties, including extremely high chemical stability, ability to repel many substances, effectiveness as surfactants, and effectiveness in extinguishing flammable liquid fires. The key chemical considerations with important implications for PFAS management include the carbon-fluorine bond, chain length, distinction between PFAAs and PFAA precursors, and polymer versus non-polymer chemistry. The carbon-fluorine bond is among the strongest bonds encountered in organic chemistry and contributes to the high chemical stability for PFAS. Chain length influences PFAS mobility in water systems, treatment efficacy, bioavailability, and bioaccumulation. PFAAs are an important group within the PFAS family that includes most of the PFAS compounds that are regulated and are included in standard analytical methods. PFAA precursors present another PFAS management challenge, as they can play an important role in PFAS mobility and contribute to increases in PFAA concentrations after certain treatment processes. PFAS are produced and used in both polymer and non-polymer forms, while polymer PFAS are generally less mobile than non-polymer PFAS. Non-polymer PFAS might be used as processing aids during fluoropolymer production, and side chain polymers may function as PFAA precursors under certain conditions.
Non-polymer PFAS might be used as
processing aids during fluoropolymer production, and side chain polymers may function as PFAA precursors under certain conditions. Finally, our understanding of PFAS chemistry and associated implications have evolved considerably over the last 15 years, continue to evolve as additional data become available. The information provided attempts to summarize the best available information into the current state of the science. Those looking for more information on PFAS nomenclature, chemistry, fate and transport, analytical methods, treatment technologies, or other areas of interest are referred to the ITRC guidance document as a comprehensive consensus-based resource.
Thank you. Madam Hearing Officer, this witness is now available for questions.
Thank you very much, Mr. Knight, Dr. Olson. Mr. Trujillo, or is it Ms. Salou? All right, thank you. Go ahead.
Good afternoon, Dr. Olson.
Good afternoon.
Ina Saluha. When you use the term PFAS in your testimony, you're referring to a broad category of chemicals, correct?
Correct.
And approximately how many different chemicals fall under the term PFAS?
There's not an exact number. You see different numbers cited based on different definitions, citing different resources. Aware of the fact I cited 12,000, previous testimony cited 14,000, all of which are over this particular number. I think as new studies come out, the number changes periodically. Yeah.
Of those numbers, how many of these have been commercialized or used in commerce?
I really am not positioned to say that. My background doesn't get into the actual use of PFAS chemicals in commerce.
You stated that of the over 12,000 PFAS chemicals, the vast majority of compounds may be considered as PFAA precursors. Do you have a more specific number of the amount of PFAA precursors?
No, I really can't get more specific than that.
And does
Excuse
this
me,
statement
Ms.
apply to
Saluja, Excuse me, are you saying PFOS or PFAS?
That question was PFAA.
I understood that. I'm just trying to get in between. Go ahead, please.
Thank you. Does this statement regarding PFAA precursors apply to compounds under normal environmental conditions or is used directly by the manufacturers?
Could you remind me of that statement?
Sure. Of the over 12,000 PFAS chemicals, the vast majority of compounds may be considered as PFAA precursors.
I would consider that a general statement. I don't know that that would have come from a citable source. ITRC may have that statement. It's a generalization.
Okay. Is it fair to say that certain PFAS compounds have been studied more extensively than others?
Yes.
And in your view, what are the limitations of applying findings from specific PFAS compounds to the broader PFAS category?
As covered in the testimony, PFAS, there's a lot of differences within the PFAS family, but there's a lot of similarities as well. So I don't think it can say that it's a good thing or a bad thing to do. It's very contextual in terms of the comparison being made.
Would you agree that depending on the context, it can be important to distinguish among different PFAS compounds rather than treating them as a single group?
Depending on context, yes.
You also noted that historically PFAS were not considered hazardous substances. Which PFAS were considered in this statement?
Really, all PFAS could be considered part of that statement. It was not until relatively recently that I think PFAS as a whole made it onto the radar screen of the environmental community.
Do you know which PFAS now are considered hazardous?
Again, that depends on definitions, different regulations, federal regulations. The term hazardous can mean quite a lot of things.
Thank you. I want to turn now to the definition of PFAS. You mentioned in your testimony that there is not one single definition of PFAS, correct?
Correct.
And that the definition of PFAS can vary by statute and purpose, but that it tends to rely more on identification of individual PFAS, right?
Not necessarily always the case.
What makes you say that?
There are definitions that are broad, that are chemical structure based, and there are other definitions that are based on naming of specific compounds.
I'm glad you brought that up because that was my next question. New Mexico's statutory definition of PFAS is a substance in a class of fluorinated organic chemicals containing at least one fully fluorinated carbon atom. In your opinion, does defining PFAS as any fluorinated organic chemical with at least one fully fluorinated carbon atom capture a wide range of chemically diverse substances?
If I'm understanding the question, you're asking if I believe that, I'm sorry, could you rephrase the question?
Yeah, of course. In your opinion, does defining PFAS as any fluorinated organic chemical with at least one fully fluorinated carbon atom capture a wide range of chemically diverse substances?
Yes, it does.
Can you explain how?
It's a broad definition. It's open. All compounds that have a fully fluorinated carbon includes chemicals that, for instance, precursors versus PFAS can have different properties, both of which would be defined as PFAS under that definition.
Thank you. I have no further questions.
Thank you, Ms. Luja. Let's see, Ms. Feebig.
We have no questions. Thank you.
Thank you very much. Mr. Boutier?
Hearing officer, no questions.
Mr. Boutier said no questions. Mr. Weatherby?
Thank you, Madam Hearing Officer. I do have one question, if you can bear with me for a minute. Okay, thank you. Dr. Olson, just one question, and this is coming from a layperson, but there are a lot of acronyms here and a lot of PF variables. Could you provide some examples of short chain PF essays?
Yes, examples of PFSAs. The most, PFBS, perfluorobutane sulfonate, would be a good example of that. Butane being a 4-carbon chain compound.
And where would one find that in consumer products or in any commercial or industrial process?
I'm not prepared to say specifically consumer products where that might be involved in. It is associated with certain firefighting foams.
Okay. All right. That was it, Madam Hearing Officer. Thank you very much.
Thank you, Mr. Weatherby. We'll turn now to, yes, redirect. Yes, Mr. Knight, do you have redirect?
No redirect.
All right. We'll turn now to questions by board members. Member Sweeney, do you have questions?
I don't have any questions.
All right. Chair Ely.
No questions?
All right. On the platform, Member Bitzer.
No questions.
Member Carrasco. I wasn't hearing Member Carrasco. I did see Member Curry's name light up. Member Curry, do you have questions?
No questions.
Thank you very much. And let me call on Member Carrasco again. He may have stepped away. Anything, Mr. Ugarte? No? All right. Thank you very much, Dr. Olson.
Thank you.
All right. Are we going to hear from Mr. Yocums next?
Yes, that's correct.
All right. Thank you. If you would please state and spell your first and last name.
My name is Andy Yocums, Andy Yocums, Jochems.
Do you swear or affirm to tell the truth?
I do.
Thank you very much. Go ahead, Mr. Knight.
Madam Hearing Officer, before we proceed with this witness, I would like to move to admit the exhibits from Dr. Olson's testimony.
All right, thank you. Do I hear any objections? Mr. Trujillo?
Madam Hearing Officer, I was looking and so I do have the same objections as before, and we'll have it as a continuing objection
All right,
to other
thank you.
witnesses.
Thank you. So your objection is noted, overruled, and you still have a continuing one to the extent that is sufficient to preserve the record. Go ahead, Mr. Knight. Sorry. The exhibits associated with Dr. Olson's testimony are admitted. I've spoken those words. Now go ahead.
Thank you. Let's see. Where are you employed?
I'm employed with the Source Water Protection Team at the Drinking Water Bureau at New Mexico Environment Department.
How long have you been employed there, and what is your current position?
I've been employed a total of about 5 years with NMED, including starting at the Source Water Protection Specialist level at Drinking Water Bureau. My current position is Source Water Protection Team Lead.
Could you briefly describe your education and professional experience?
I have a Bachelor's of Science in Environmental Science from the University of New Mexico and a Master's of Science in Geology from Utah State University. I worked for about 9 years in field geology with the New Mexico Bureau of Geology and Mineral Resources, a non-regulatory agency based out of New Mexico Tech University in Socorro. That job tenure primarily included field mapping of what we refer to as hydrostratigraphic units. These are the basin fill and other sedimentary units that play host to many of the aquifer resources in New Mexico, including those that serve the cities of Santa Fe and Albuquerque. Since I've been employed with NMED, my work on the Source Water Protection Team has included primarily working on source water protection plans, non-regulatory documents for public water utilities, as well as serving as a PFAS expert and a coordinator for various water sampling projects and technical group activities, as well as data screening and data review activities with the department.
Great. Did you file a written testimony in this matter?
I did.
And do you have any corrections that you would like to make to that written testimony at this time?
I do not.
Do you therefore adopt that written testimony as your testimony here today?
I do.
Please provide us with a summary of your written testimony.
Thank you. Thank you, Madam Hearing Officer, Madam Chair, and members of the board. My name is Andy Yocums, and I am the Source Water Protection Team Lead at the New Mexico Environment Department. My team assists public drinking water utilities to protect their drinking water resources through source water protection plans and assessments with guidance from the Federal Safe Drinking Water Act. We also conduct environmental reviews and investigate the impacts of different types of contaminants on drinking water resources. I present this written testimony summary on behalf of NMED in support of the petition for regulatory change to adopt 20.13.2 NMAC, PFAS in consumer products, hereinafter the rebuttal rule. The purpose of my testimony is to provide overviews of per and polyfluoroalkyl substances and source water protection, and also to discuss how the rebuttal rule will benefit New Mexico's drinking water resources by reducing PFAS contamination. The Safe Drinking Water Act provides for the assessment and protection of sources of public drinking water. The U.S. Environmental Protection Agency provides guidance and encourages partnerships for the voluntary process of source water protection planning, which is part of a multi-barrier approach to protecting drinking water resources, drinking water quality, and human health. The underlying principle of source water protection is that prevention is the most effective, efficient, and economic method to assure safe drinking water over the long term. The NMED Source Water Protection Program works to provide water utilities with source water protection plans developed through two broad phases. The first is assessment. This involves determining different types of potential and actual contamination threats. And the second phase is protection. This involves developing planning and mitigation strategies against those threats. All drinking water sources, aquifers, rivers, and springs are vulnerable to contamination under their requisite circumstances. PFAS can severely impact a water utility's capacity to provide safe drinking water to its customers, but it can be mitigated through the source water protection planning process. As we heard from Dr. Olson's testimony, PFAS are a very large family of human-made chemicals that repel water, oil, and grease and withstand high temperatures, and certain PFAS chemicals have toxic properties. I won't review these general physical chemical properties nor toxicological properties of PFAS, but do want to point out, as was mentioned by both Dr. Olson and Dr. Chapman's testimony, their propensity for bioaccumulation and resistance to breakdown, at least among certain families within the broader PFAS group. The Environmental Protection Agency set maximum contaminant levels for 5 different PFAS chemicals, as well as a hazard index in April of 2024. EPA has subsequently proposed the retraction of 4 of 6 maximum contaminant levels in 2025, but this has not yet occurred. Some states have also promulgated their own regulatory standards in drinking water for PFAS. As we have heard today, PFAS chemicals are widespread in the environment worldwide. PFAS discharges to water supplies can occur from domestic sources, landfill leachate, chemical spills, and/or wastewater discharge, among other environmental pathways. Domestic or residential sources of PFAS can contribute these contaminants to wastewater. Municipal utilities with wastewater treatment plants eventually receive domestic water and wastewater influent, whereas rural residences commonly rely on on-site liquid waste systems, better known as septic systems. Both wastewater treatment plants and septic systems are known secondary or passive sources of PFAS. Other secondary sources of PFAS include landfills, illegal dumping, chemical spills, urban runoff, and even permitted discharge of wastewater. All of these also represent threats to drinking water sources in New Mexico. Regulated public water utilities in our state serve approximately 95% of the state's population. PFAS maximum contaminant level exceedances have occurred at 25 utilities in the state, 21 of which are considered small systems under the Safe Drinking Water Act. These small systems often have limited resources to address contamination in their drinking water. Additional detections are expected through ongoing monitoring as we enter the compliance phase of the PFAS rule passed at the federal level. The best available technologies identified by the Safe Drinking Water Act for treating PFAS, in other words, removing PFAS from drinking water, are expensive, and small public water systems in New Mexico may not have the adequate resources to implement these technologies. For reference, the cost of removal and destruction of PFAS from wastewater effluent ranges from about $3 million to as much as $18 million per pound of PFAS removed, and is disproportionately borne by smaller utilities. This is for wastewater utilities, but I will say that a similar economy of scale is anticipated for small drinking water utilities. Critically, upfront prevention of PFAS contamination in drinking water resources would be a major benefit of the rebuttal rule, benefiting consumers of both public and private water supplies and saving utilities a significant amount of treatment cost that would otherwise be passed on to the ratepayer. In conclusion, PFAS are a large family of human-made chemicals that can be toxic. Source water protection is the non-regulatory process by which public drinking water utilities can be proactive in protecting their drinking water resources from PFAS and other contaminants. Source water protection often relies on local, state, and/or federal regulations to have a real-world effect on drinking water sources and protecting them. The rebuttal rule is a critical regulatory intervention with clear benefits for source water protection because the removal of PFAS from commercial products will reduce the introduction of these contaminants to drinking water resources. I therefore urge the board to adopt the rebuttal rule to protect New Mexico's drinking water resources from preventable PFAS contamination and safeguard human and environmental health in the process. Thank you.
Thank you very much. This witness is available for questions.
Thank you very much, Mr. Yocums and Mr. Knight. Mr. Trujillo, or Ms. Saluja, do you have questions of Mr. Yocums?
Madam Mayor, I'm sorry, I have a few. Mr. Yocums, good afternoon.
Good afternoon.
So is your testimony, the testimony you present, is it to argue that the labeling of PFAS will somehow help with meeting drinking water standards?
My testimony is to argue that the rule as a whole will help small in particular, but all public water utilities meet and not have to worry about drinking water standards for PFAS. But shining a lens on the labeling aspect of rule in particular gives consumers the ability
Mr.
to choose
Yocums,
between-
your microphone? Oh, Mr. Trujillo.
It was on.
Oh, okay. Sorry, it didn't seem like it was on. I'm sorry for the interruption.
Okay.
No problem.
Go ahead, Mr.
And to the second part of my statement, the labeling component of the rule would give consumers the ability to choose between products that contain versus those that do not contain PFAS, thereby, considering the adoption of this as a whole and giving this ability to consumers across entire municipalities in the state as a whole would benefit drinking water supplies by giving people the choice and the option to use non-PFAS containing products.
Is that because the label is signaling that PFAS is bad in some way?
The label simply signifies that the product contains PFAS.
What types of PFAS are typically found in drinking water?
Let me clarify which types of PFAS are typically found in drinking water. We've heard today from testimony from Dr. Chapman and Dr. Olson that there, for example, are short versus long chain varieties of PFAS compounds, as well as polymeric and non-polymeric types of PFAS compounds. All of these can be found in drinking water resources in New Mexico, and the majority of these types have been found in drinking water resources in New Mexico, including resources utilized by public water utilities.
Thank you. Let me look at my notes and that may be it. Hold on real quick. At the top of page 6 of your direct, you seem to indicate that the proposed rule will impact various sources of PFAS. Are you saying that the rule will regulate these sources, or see what I'm at on page 6?
Could you recite the first few words of that paragraph, please?
The revised proposed new rule would also impact non-domestic sources. You see where I'm at the very top paragraph?
Yes.
Are you saying that the rule will this rule will regulate these sources?
The rule will not regulate these sources directly. These sources are mentioned here because they're all what we've heard to refer today as secondary or passive receivers of PFAS contamination, runoff, et cetera, from the use of PFAS containing products in both residential and commercial types of spaces.
I have no further questions.
Thank you, Mr. Trujillo. Ms. Febeck?
We have no questions. Thank you.
Thank you. Mr. Boutier?
No questions.
Thank you. Mr. Boutier said no questions. Mr. Weatherby?
Madam Hearing Officer, I have one. And let me go to Mr. Yocum's written statement that was submitted on page 7 at the conclusion. You refer in the next to last paragraph to solid waste disposal and accidental chemical spills. Can you give examples of what the chemical spills might be and what you believe the source of those spills would be?
I'm happy to. I feel confident in saying the best known type of chemical spill in our state, at least, would be from PFAS containing firefighting foams on several of our Air Force Base installations. But there could be other types of chemical spills as well. This might be fabric softeners, other liquid materials, pesticides, for example, that contain PFAS and are stored at a given facility and accidentally spilled for whatever reason.
And any other examples, or is that pretty much your understanding of what it might be limited to?
These are what I would consider probably to be some of the more commonly expected types of chemical spills.
Okay. All right. Thank you. That would be it, Madam Hearing Officer.
Thank you. Mr. Knight, do you have redirect of Mr. Yocums?
Yes, just one question, I think. In your earlier answer, you mentioned that the department's objective or hope with labeling was that it would allow consumers to make a choice. And is it also true that labeling could also result in manufacturers reducing their use of PFAS or putting more energy into exploring alternatives to PFAS in their products?
Yes, absolutely. I think there is an economic incentive to be derived from that at the manufacturer's level and to be seeking out other alternatives for these chemicals in these products. And perhaps the burden of labeling that we've heard about today would be an instigation of such practices.
That's all I had.
All right, thank you. We'll turn then to the board. Member Sweeney, do you have questions of Mr. Yocums?
I don't at this time.
All right, Chair Ely.
Just a couple, Mr. Yocum. You mentioned there are about 100,000 private systems in the state, people who rely mostly on groundwater for their source of water. We know we have contamination issues in La Cienega and La Cieneguilla with PFAS, and I believe the department is trying to help those residents control or the PFAS that may be in their groundwater. Do you know about that scenario and what it might cost to help those folks out in that village with PFAS in their water? And is it effective to get the levels down to where they can drink it or bathe in the water?
Madam Chair, thank you for your question. I am familiar with the contamination at La Cieneguilla. I do not know an exact dollar amount figure for remediating PFAS in the groundwater. However, simply testing for PFAS to find out whose homes and whose private water sources it's affecting is costing in the millions of dollars due to the expensiveness of the analytical side of testing for PFAS. All told, remediation is, I think, reasonably expected to be significantly higher than that.
Thank you.
Thank you. On the platform, Member Bitzer, do you have questions of Mr. Yocums?
I do not. Thank you.
Thank you. Member Carrasco?
I do not.
Thank you. Member Curry?
Yeah, I have a kind of a general question, and my apologies if I didn't hear it or missed it. As far as the data that you've presented, could you give us some sort of current dates as to that data? And is it one date, or is it many dates, or is it? I'm just curious as to the relevancy of time to now.
Madam Chair, Board Member Curry, could I ask you to please clarify which data you're referring to?
All of it.
All of it. Thank you for the question. In terms of the data reflecting the number of New Mexicans served by drinking water, either private or public drinking water supplies, that is current as of this month. according to data from the New Mexico Environment Department's Drinking Water Bureau. In terms of the PFAS chemicals that have been detected in drinking water supplies around the state, as I mentioned, monitoring efforts are ongoing. This data is current as of the filing date of the written testimony on January 16th.
Thank you very much.
All right, thank you. Anything further from the board? No. Mr. Knight?
Madam Hearing Officer, at this time, I would like to move admission of the exhibits from Mr. Yoakum's testimony.
Objections? All right, good. Mr. Yoakum's exhibits join Dr. Olson's and Dr. Chapman's exhibits as being admitted. And thank you very much, Mr. Yoakums. It's an excellent speaking pace.
Thank you, Madam Hearing Officer, Madam Chair, and the board.
All right, we're not going to be able to make it to 5, which is when we'll break around 5 without another short break. Should we do that now before we hear from Dr. DeWitt?
Madam Hearing Officer, I'm sorry, this has moved a lot faster than we thought it would with 7 parties, but we do not have a witness to present until tomorrow.
Aha, all right. Is there anything else we can do while we're together this afternoon that another party would like to do?
Madam Chair, it's our understanding that our witnesses are scheduled, we've scheduled all of them for Wednesday. And due to the pace, not trying to readjust, but that we've had those 2 firmly committed to Wednesday.
That's fine. I'm just asking. Anyone else? Anyone else at all? Okay, well, we can certainly break earlier today and we can see you tomorrow morning at 9 o'clock. All right, thank you all.
Thank you, Madam Hearing Officer.